This trial is in the matter of CFI 025-2020 before Justice Lord Angus Glennie and is being held of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Kochar & Co. legal consultants. Lead counsel is Nikat Khan. The second and fifth defendant are represented by Bistwins Law Corporation for legal consultancy. Lead counsel is P.V. Shaheen. The fourth defendant is Mr. Vijay Kapoor, a litigant in person. The 6 to 8 defendants are represented by KBH Limited. Lead counsel is Ms. Zara McClone, assisted by Tina Asgarian.
Thank you very much. Right now, is it Ms. Nikat or Ms. Khan?
Anything.
Which do you normally go by?
Nikat, Mrs. Khan, anything.
Okay, Mrs. Khan. You're acting for the claimant, I think.
Yes.
And I've seen exchange of, well, I've seen emails between you and the court and between your counsel or your former counsel and the court. What is your position about proceeding now? Are you making any application or are you ready to go ahead?
I would request you, if I'm just granted 2 days, I had approached the defendants and the defendants want a cost to be paid, and that is something my client is not willing, because we have already lost the cost on the barrister, which is our problem, and we had paid full fees to the barrister, but she's going to only refund half, and so that's the first half is a loss for us, because now we have to engage another counsel and pay him full amount. And I don't believe that for a period of 2 days it would cause any difficulty to anybody. But
Well,
if
hang on, if we adjourn for 2 days, we'll only have 3 days left, and the case can't finish in 3 days.
True. But we can extend it to another 2 days after the week, if that's okay with everybody. Or even if you give us 24 hours, that will also help us.
Well,
As it is, the defendant is planning to, during the trial timetable, is planning to speak on his application for almost 2.5 hours. So we are not going to meet the deadline set in the trial table. So we won't be able to finish it within 5 days.
So what are you asking for?
If you can give me 2 days, I'll be very grateful. If you can give me 1 day also, I'll be very grateful. If no, you cannot, nobody can accommodate, then I have no choice.
No choice but to what?
To appear.
So you're not, so if it's a question of the other side, as I've seen the 6 to 8 defendants note this morning, and they say, well, if you're going to adjourn, it should be to a date to suit us or convenient to them as well as to other parties. You don't want that?
No, I have no problem. In fact, I had discussed with all the defendants, and these 2 and 5 had said that they are very busy, and they are very busy for between 8 to 20. But these 6 and 8 are available only in the month of November and December, and we cannot prolong the trial so long. We have waited for 3 years. So it's just a short adjournment, which I was looking at, but parties' timetable is schedule is very tight and they cannot assist or not that. And plus D6 to D8 wanted certain costs to be paid, and which we are not willing because.
Okay. So you want an adjournment? You want an adjournment, but not for more than 2 days.
Yeah, 2 days is more than enough.
And you're not prepared to pay the costs caused by the adjournment.
Because I understand they are definitely, they would want it because they have to extend the stay, but that is something we are not looking at, because the bank is going to face serious consequences of selecting a barrister who walked out just 2 days before the trial, and payment of any cost will reflect that decision of hiring such a barrister who left 2 days before the trial.
Right. But if I was to grant you a 2-day adjournment, that would inevitably mean the case would run over into another date to be fixed, and that would incur costs. You would agree to pay the costs caused by that adjournment?
This is what is my problem, that the client cannot have anything on record that the cost is being paid, because the bank will be questioned by his board that why
No,
are you paying this cost?
I just want to know the position. The answer is you're not prepared to pay the costs of any adjournment.
It's not that we don't want to pay, but we cannot pay.
Whether you want to or not, it doesn't. You are not offering to pay the costs caused by any adjournment.
Cost in the case we are fine, but not
immediately. If I were to be agreeable to the adjourning for 2 days, but I made it a condition that you would pay the costs caused by adjournment, you would withdraw your application or you would pursue it?
I didn't file an application.
No, you're applying now.
Okay.
Or if
I will withdraw my application because
costs is a no go. Yeah. Okay. Right. That's helpful. Thank you. Do I take it? Who's acting for the second to fifth defendant? Mr. Shaheen, is it? I can't hear you.
Good morning, Your Lordship.
Good morning.
Am I audible?
You're audible now. Yes, thank you.
We have serious objection and the matter being moved to next week from 8th to 20th of this month. We are not available.
Yeah. What about after that?
After that, any date convenient to all the parties.
But are you opposing the, I'm going to call it an application. Are you opposing the application to adjourn, or are you agreeable to it provided it's not within the next week?
We are opposing the application and we are asking for costs, and it cannot be moved to next week as my friend suggested just now.
I see. Thank you. Mr. Kapoor, you're acting for yourself. Do you oppose the adjournment? You're muted. I can't hear you.
Yeah, can you hear me now?
I can hear you now, thank you.
Yeah. My position is that I had prepared for this trial as well as my witness to be available this week, and I would not be able to, extend it to the next week because even the witness, which is expert, who's going to depose in one of the hearings on Thursday, he is not in town. He'll be traveling. So in fact, it will be impossible to conduct and complete the trial without his availability again.
Yes, and he's available this week.
This week on Thursday, I had requested him to postpone his trip and somehow got him to agree.
Yeah, okay. And Ms. McClone, you're acting for the 6th to 8th defendants, is that right?
My lord, I am, but actually Ms. Asgharian is going to address you on these points.
Ms. Asgharian.
Good morning, my lord. In terms of D6 to D8's position, next week they are both counsel, KBH, and our witnesses are unavailable. And therefore, in the event that the trial is postponed by a couple of days, it will have to go part heard. In those circumstances, my lord, based on previous experience, that tends to cause a lot more in terms of wasted costs in trial by the time we can fix another date and the parties have to start all over again. Therefore, the preference would be, if Mrs. Khan is pressing for an adjournment, that it should be at a later date convenient to all parties and all matters are dealt with during the course of a one-week trial as originally planned.
And on the question of costs?
We are seeking our wasted costs.
Yeah, but it sounds to me as though Ms. Khan is not wanting to pursue an application for an adjournment if it carries with it order for costs against the bank. I've got that right, Ms. Khan, have I? So it seems to me any adjournment because of the claimant difficulties would have to carry with it an order for costs wasted by the adjournment, and therefore I treat the application as withdrawn. Is that right?
Yes,
All right. Very well. I will ask the court to record the fact that the application made orally for an adjournment is withdrawn. I just want to make sure I've got that right, Ms. Khan. Is that right?
Absolutely right.
Very well, thank you. Now, I was sent a supplemental skeleton argument this morning by the 6th to 8th defendant. That's you, Ms. Asgharian, I think. And I also got an application by the 4th defendant, Mr. Kapoor, which is best. Shall I hear? Well, Mr. Kapoor, the difficulty of your application made at this late stage is that if it's heard before we start the trial, then we are going to lose a day of the trial.
Your Lordship, I think it's important to consider that matter because as you had, yourself passed an order in the pre-trial hearing that this is an important matter which I should be allowed to take up because I had raised this matter in the first witness statement itself during the earlier trial. So I sent an application. I was told that it is being considered. And then I got this reply from the registrar that, it is being denied without giving any reasons whatsoever.
The problem, Mr. Kapoor, can I just interrupt for a moment? At the pre-trial review, I think it was, when I mentioned that, of course, it was open to you to raise the point. That was in March, more than 2 months ago. I hadn't anticipated that it was going to be raised just a few days before the hearing.
I submitted my application with all the documents and everything after, thereafter there was time given to the claimant's lawyers to respond. Thereafter, in fact, the deadline which was fixed that, at 8 a.m. they would put in whatever their objections were, but they did not respond in that time. They asked for another day after that. After which we were asked to be patient and wait because all the matters had been placed before the registrar. And we waited for 3 days and then just suddenly got an order saying, where we had requested specifically for a hearing.
Mr. Kapoor, I'm not concerned with 3 days here or there. I'm concerned with the fact that when we discussed it, it was in March, I think, the pre-trial review, and yeah. you renewed your application only in May, I think.
1 second, I'll tell you the date on which I actually made that application. First and foremost, sir, there was a second witness statement or first witness statement filed with the claimant on 4th of April by Ms. Anjali. And thereafter, as far as I'm concerned, I filed the complete reply with all the documents on the 10th of May. Because basically we had to compile all the documents and we had also received requests from other counsel seeking all the communication which had happened between Kocher and company and myself, which we also supplied to them. So the matter was raised by me several times during my witness statements throughout the course of the trial, and it never had an opportunity of being heard on this. So basically, what I had requested in my application was to give us a hearing, and that has unfortunately not been granted. So it is my humble submission that unless and until this matter is properly heard, we will not be able to find a solution, and I'll be denied my right to at least a natural justice, where at least the facts which I have placed in writing can at least be properly explained to get an order.
Right. Okay. We'll come back to that in a moment. Then I just want to hear identify the other issues that need to be resolved. Okay.
If I may interject, Your Honor, I just want to clarify the application 11 was filed on 10th of May. And we were so tied up in the trial that we could not respond within the deadline set. And regarding collection of other documents which D4 is contending, they have just simply repeated the documents that are already there in the bundle. There was nothing new. And lastly, the first application they made was under where there is conflict of interest was under default judgment application. It was not an application for conflict of interest. It was an application to set aside the default judgment. The grounds were mentioned as conflict of interest and other grounds, but it was not an application. This was the first application filed on the 10th of May following the PTR order, which was held in March.
Yeah.
Your Lordship, actually, in terms of procedure, I was not aware that there's a separate application which had to be filed for this. In fact, the previous judge who was handling the summary judgment could have probably guided or, told us that this is something which can be heard as a separate point. In subsequent witness statements also, I have raised this point several times. And in fact, to be honest, if you just look at the witness statements provided by the claimant's lawyers, they have themselves contradicted themselves on many occasions. The first time when we raised the issue of conflict, all they said was that they had mattered basically handled one small case in Fujairah for me. Whereas in their own witness statement, they have now come out and said what all they were handling for me. So it is a serious issue, and it will be my humble submission to consider it and grant us a hearing, proper hearing. 2 hour hearing is more than sufficient to consider on both sides of the thing and to request a ruling from you.
We'll come back to that in a moment. I just want to hear from Ms. Asgharian about the other matters that have been raised in her supplemental skeleton argument. Ms. Asgharian.
I'm grateful, my lord. In those circumstances with the trial proceeding, there are two outstanding matters to set out in my skeleton argument. There is one additional matter which has come to light as we've been on this call. The first matter is whether or not the bank's witnesses can give evidence from India in the absence of any evidence that competent authority in India has given permission. The second matter is a smaller issue of a late witness statement that was filed last week without permission to file out of time, and whether or not the claimant is entitled to rely on that evidence as part of its evidence at trial. The third issue, my lord, is I noticed that Mr. Vajani is on the call, and I'm not sure if he's co-counsel, but I understand he's not part to registered and therefore doesn't have any rights of audience before the DIFC courts. I don't know if he's planning on undertaking any advocacy during the course of this trial, but we would just flag that as a final housekeeping point.
Well, let's deal with that first. Mr. Vajani, you're on the screen anyway. I don't know where you are. Are you intending to appear? What is your position?
Yes, I intend to appear for the claimants, and I am given to understand that I do have a provisional registration with the DIFC courts.
A provisional registration? What is? Sorry, you have to help me on that.
I will get a clarification from the registrar on that account, because I was given to understand that I do have a provisional registration which would entitle and enable me to address your lordships. But I will come back.
And so you are proposing to act with Mrs. Khan?
That's right. That's right.
Well,
since this objection has now been raised, I will seek a clarification from the registrar on this counter right away.
If you can do that while we're discussing other matters.
Very well, Judge. Very well.
Right. Now let us deal with can we deal with the late witness statement first? What is the Ms. Asgharian, you say it's a minor matter. Is there any real prejudice caused by that witness statement? Is it, in other words, is it a matter of simple non-compliance with the rules, or is there some more fundamental objection?
There are two issues, my lord. The first is non-compliance with the rules. The second is that none of the parties have had the opportunity to respond to that statement. It is minor in the context of the first issue that I raised, but nonetheless it is an important matter. It relates to matters which predate the order for the filing and service of evidence in chief and reply evidence. The facts and matters stated in there are not new, and no explanation has been provided as to why this statement was filed late and without the permission of the court. But more fundamentally, my lord, as I stated at the outset, none of the parties have had the opportunity to properly consider and or respond to this evidence.
When did you see it first?
It was on the 26th of May.
That's what today is 30th. So you've had it for 4 days. You've obviously had an opportunity of at least a quick look at it. Does it cover matters which you can't in fact deal with through the witnesses?
We ought to be able to deal with it if required, my lord. It's just unusual for this to have been filed so late when there was no good reason for it to be filed late. I understand that the defendant number 5 may also have some observations to make on this late filing.
And what's the name of the witness?
It is Mr. Rajat Grover. And it can be found at tab G/372 of the trial bundle.
Right.
Your Honor, if I may just clarify.
Yeah.
This is an affidavit, and I had informed the defendants that I am going to file an affidavit because when I carry out a publication in the newspaper, I have to file an affidavit to let the court know that I had carried out the publication and no defendant came forward. It's just a formality. Mr. Rajat is not going to provide any evidence in trial. He's not a witness. It's just a procedural document that has been filed to confirm that this is a publication copy. This is how we serve the claim form on D1. That's it. That's it.
If that's all it is, it doesn't sound as though it's going to cause you any problems, Ms. Asgharian.
My lord, if it's simply procedural, then presumably it's not really required, and therefore we can make submissions as to the weight of the evidence in due course.
Well, I think what I'll do is I'll treat the application as made now to admit that, or to admit it late, and subject to, I will allow it to be received, and allow all parties to make whatever comments they want us to wait. Very well.
I'm grateful for that indication. My lord, that leaves the more pressing issue, and that is the question of taking of evidence from persons located abroad. I very much appreciate that my skeleton was sent early this morning UK time,
Yes,
and therefore
I've had a quick look, but there seems to be a number of authorities cited in it. Is this an area where there's quite a lot of authority? Case law.
There certainly is, and the authority that has been cited is all post-COVID, just to demonstrate that even though courts are now moving much more towards a system where hearings are being undertaken remotely, nonetheless the necessity and the need in order to comply with this requirement is still being enforced, certainly by the English courts. And to that end, I think perhaps the most appropriate and most helpful authority is the Interdigital Technology Corporation case, and the relevant section there can be seen at page 17 of the short bundle that was filed with our skeleton argument.
Hang on a second. Page 17.
Yes.
Sorry, every time I get a document up, I lose your picture. Right. Yep.
Paragraphs 4 to 6 of the judgment, Justice Hagel there, it sets out the position and the need for obtaining the relevant permission from the foreign court.
Paragraph 4.
4, 5, and 6.
Just give me a second though. Shall I just read them quickly?
Thank you.
Yeah, I've read 4 to 6.
Thank you. So, and there, my lord, the court has set out the general requirement. It's not so much that any of the parties, and that is very much the case here, we do not object in principle to the witnesses giving evidence, but this becomes an issue of sovereignty and public policy, that the relevant permissions need to be obtained. And those were.
Can I just interrupt? When I read your skeleton, I was just wondering whether this is really a matter for the court as opposed to the party calling the witness, whether, and if it turns out that that they are acting contrary to Indian law, well, they will take the consequences. Why does this court get involved?
It may also be an enforcement point, but then to answer that question, my lord, perhaps I could take you to page 7 of the documents that were page 7 of the bundle of documents that were filed with the skeleton argument.
Sorry, I interrupted you. Did you want me to take? Did you want to take me to anything else in the judgment?
It was only to the final paragraph at which is at page 25 of the bundle, my lord, where in that particular case the court noted that it was an issue of sovereignty, the need to obtain this permission. And therefore, whilst permission to take evidence by video link would be given, in order to ensure that there was no breach of the relevant laws of that country, the court would only allow the evidence upon the party calling the witness, satisfying the court that the relevant permissions had been obtained. And my lord, that really feeds into the comments made in the immigration upper appeal decision, and the relevant sections appear at page 7 of the bundle.
Yeah. Yeah.
Where in that case, it was noted that the vast majority of countries, and this is, section D at the top of the page, the vast majority of countries with which immigration appeals, even asylum appeals, are concerned are countries with which the United Kingdom has friendly diplomatic relations. And it is not for an immigration judge to interfere with those relations by not ensuring that inquiries of this sort have been made and that the outcome was positive. And therefore, to that extent, my lord, that is why we submit that this is a matter for the court to consider, because these go to issues of sovereignty, public policy, and diplomatic relations. And to that extent, the prudent course would be to ensure that the relevant authority had been obtained from the competent courts in India. And that also resonates with the practice note issued by the Right Honourable Sir Julian Flo, which can be found at page 36 of the bundle in relation to proceedings in before the courts of England and Wales.
Mm-hmm. Do you want me to read the practice note?
Only the first paragraph, my lord, as that deals with the requirements.
Give me a second then. Is there any equivalent practice note in the DIFC?
My lord, there isn't. In the DIFC, there is only the protocol for video conferencing, which appears at page 1 of the bundle. But what I will note is that the wording of that protocol mirrors almost verbatim the provision in the English CPR, which I've also included.
Where's the CPR?
At page 26 of the bundle, I've included the extract from the CPR, which mirrors the wording in the DIFC.
This 32 PD 33.
Yes, and my lord, it's paragraph 4 of the practice direction, which is almost in identical terms to paragraph 4 of the DIFC protocol, which appears at page 1 of the bundle.
Right, give me a second then. Yeah, page 1, you say?
Yes, my lord. Page 1, paragraph 4.
Again, what this protocol doesn't make clear is whether it is a matter of that the responsibility lies on the party, and if the party doesn't get permission, then it will face the consequences, or whether it is for the local court, domestic court, to take the initiative and prevent evidence given without proof of that it's permitted under the foreign law.
My lord, to that point, I would respond as follows: that given that the provisions of the provisions of the DIFC protocol follow the English protocol, and then from the English protocol, if we look at the recent practice direction issued by Justice Flo, and also the 2 authorities that I took your lordship to,
Yeah.
then by extension of the reasoning and the rationale set out in those authorities, there is also there is the requirement for a certain degree of judicial intervention in the event that the relevant permission hasn't been obtained, to ensure that issues of sovereignty, public policy, diplomatic relations, etc., are not interfered with. And that must also equally apply in the DIFC as it applies in England. Now, I haven't been able to find any authorities where the position was considered this late in the day, on the basis that all of the authorities that I have reviewed, the issue was raised at the PTR, or certainly before trial, and the relevant directions were put in place to ensure that evidence wasn't given in breach of any foreign laws.
This has been raised at this late stage for what reason?
It was only during the course of preparation, my lord, that we noted that the claimant's witnesses were based in India. We wrote to the claimant to request confirmation that the relevant applications or permissions had been sought, on the basis that the usual procedure, at least in England, is that those permissions are made or sought on an ex parte basis. The other parties do not need to be advised of that, but it is common when requested to provide that confirmation. Upon requesting confirmation of the same, the response was received on Saturday that there is absolutely no such requirement for Indian nationals in India, and no relevant permission is required. But there is no evidence in support of that assertion, and certainly from our review of the Indian Code of Civil Procedure, it would appear that letters of request do need to be made to the competent court in India for permission for their nationals to give evidence before a court of another jurisdiction. From
India. Yeah. I see. Do we have? We don't have that in the bundle.
We do, my lord. I've included those at pages 31 to 34 of the bundle.
Whereabouts on page 31, sorry.
Page 31, it's section 78, commissions issued by foreign courts. Now, this was drafted, I believe, in 1908, and therefore the relevant explanation or expansion of the civil code can be found at page 34 of the bundle, which is an extract from Order 26, which amends the CPC. And at paragraph or section 20 of that order, Rule 20, I should perhaps say, in there it refers to the High Court issuing a commission under Rule 19 upon an application by a party in the proceedings before the foreign court, or upon an application by a law officer of the state government acting under instructions from the state government. It is our understanding that those provisions do require a letter of request to be made in circumstances where both parties are not signatories to the Hague Convention on the taking of evidence abroad.
And the DIFC is or is not party to the Hague Convention?
The UAE is not a party to the Hague Convention, but India is.
Right, and does the fact that India is a party mean that as far as India is concerned, there is no problem, or does it have to be a reciprocal arrangement?
My understanding is A, it must be a reciprocal arrangement, and B, the Section 17 waiver under the Hague Convention also needs to be obtained. And I haven't been able to locate one for India in that regard, but primarily because the UAE is not a contracting party, therefore there won't be that reciprocal agreement.
I see. Very well. What do you suggest in practice we do? If I was sympathetic to your submission, are you suggesting therefore that the witnesses can't be called and the claimant's case fails? Or are you suggesting that we defer it adjourn for a few days, or what?
Well, our primary submission, my lord, would be that the claimant's witnesses cannot be called in those circumstances.
Right. Very well, Mrs. Khan, what's your position on this?
Well, the skeleton argument and whatever application they have made, it was too early. I mean, they have provided us too late. If it was provided to us earlier, we could have taken an opinion. We have Mr. Bajani here, and I believe that he has the approval to appear soon. The registrar may contact you for the same, and he is the best who can confirm, but I have checked and confirmed, and all my counsel, because we are a very big law firm in India. My office has confirmed that there's no such requirement to seek permission, and they have conducted many proceedings with witnesses in India appearing in UAE proceedings. So as such, there is no such requirement, and that's why I replied to Ms. Asgharian that there is no such requirement. So we haven't, but if she wants to formally proceed, then we need time to respond to a late skeleton that has been filed. We can seek a legal opinion from a counsel, and then, but suddenly on the trial day, you submit a skeleton argument and let me know that my witnesses will not be allowed to appear. It's just not fair.
Well, I think maybe the way around it is this. I'm going to suggest a course and invite your comments, both of you, that we allow the witnesses to give evidence subject to it being confirmed by the end of the week that there is no difficulty from the Indian law point of view. If there is, then their evidence will simply be discounted.
Okay, and for that, a simple opinion from a law firm is enough?
Well, I'm not going to tell you what evidence you need.
No, because then they'll say you need to get a court order, and getting a court order from India is a daunting task. It will not be done in 1 week's time.
Well, then if you need an order and you haven't got it, then the witnesses can't be heard. So
we don't need an order.
Well, then you show that you don't need an order by whatever means is appropriate.
Okay.
I'm not going to dictate precisely what is needed, because I don't know what will happen, but it seems to me as I'm allowing the evidence to be given subject to it being shown that there is no difficulty from the Indian law point of view with them giving evidence from India. Ms. Asgharian, is that, do you want to say anything about that? It seems to me that we are where we are in terms of timing, and that is the practical way forward.
And if we have to look at it this way, then D4 also cannot give evidence because he's based in India.
Who's that?
D4.
D4. Very well.
Thank you.
Ms. Asgharian, did you want to make any comment about that?
My lord, no, that seems the best and most practical way forward. I think the only question I would raise, but only because I've never been in this situation, is do the witnesses need to be given a warning before they give evidence that they are comfortable to proceed where potentially they are in breach, or does the fact that if the claimant cannot satisfy the court by the end of the week cure that, because the evidence will effectively then be discounted?
That's an interesting question, but I don't think I can give any ruling on that. I suspect the answer to an English trained lawyer is simply to say that because it would be discounted at the end of the week, it wouldn't be a breach, but that's not an opinion of Indian law, so I can't help on that.
I have discussed with Mr. Vajani and he said that let this issue be deferred post lunch and we will get back to you on the requirement whether, because what she has quoted, I believe is no longer applicable.
Okay, well, we'll take it forward on the basis that my present decision is to allow the evidence to be given subject to it being confirmed by the end of the week, that there is no difficulty from that point of view.
We are grateful.
Mr. Kumar, I think you are Kapoor, sorry. I think you, where's Mr. Kapoor? He's disappeared. Oh, there you are. Are you giving evidence from India in due course or from the UAE?
From India.
From India. Well, you've been following the discussion.
Yes, I have been following the discussion.
So can you take steps for yourself to satisfy the court in due course that you're entitled to give evidence from India? You may want to just rely upon what the claimants find out, or you may want to make your own inquiries. But I should say that it seems to me that the same approach must apply to your evidence as to the other witnesses from India.
Yeah, but I will also certainly make inquiries to that respect.
Very well, thank you very much. Now, Mr. Vajani, have you spoken to?
Yes, we did. We did, and I'm given to understand that the court clerk on the call would inform your lordships about the position of DIFC.
Maitha, is that? Do you know what the position is?
Yes. So, yes, Judge. So, Mr. Vajani did not initially register with the DIFC court's legal practitioner. So what we have done is that the registrar has granted him permission to attend today's trial, and that he will initiate the registration process. So, like in terms of attending today's trial, the registrar has granted him permission to do so.
And for the rest of the week?
Yes, so yeah, so I believe what will happen next is that the registrar will assess his registration straight away, and that he will have his answer, I believe, by the end of day today, whether his registration is approved or not.
Thank you very much. Could you perhaps ask the registrar to let me know, or through you, let me know the position at the end of the day or by tomorrow morning?
Certainly, Judge.
Thank you very much. Right, that's, I think, all the D6 to 8 housekeeping matters dealt with. The only question that remains is Mr. Kapoor and the confidentiality matter, conflict of interest. I'm reluctant to delay the evidence more than necessary, but it seems to me if this matter has to be dealt with, it has to be dealt with now before we start the evidence. And what time is it now? It's 9:45. I think what we should do is try and reduce the disruption to a minimum. I think we should resolve the question between Mr. Kapoor and the claimants as the next stage. Hopefully it won't take more than an hour, but it might take a bit more than that. So what I would propose to do, since the other parties don't have any say in this matter, I don't think, is to allow that discussion to take place between Mr. Kapoor and the claimants. And on that basis, I will allow other parties to leave the virtual hearing for at least 1 hour. Yes, Mr.
D2 and D5, we have certain things to say regarding the conflict of interest. We submitted our notes on this.
Right, you'll have to help me on that, but anyone who doesn't want to take part in this discussion, feel free to leave for the next hour or so.
My lord, may I ask two or just raise two points? The first is, I presume we may be permitted to observe the application even if we're not taking part.
Yes.
The second, and I'm loath to speak on behalf of my learned counsel, co-counsel Miss Glennie, but I wonder if it assists the court, perhaps the parties can dispense with opening oral submissions on the basis that the court has received detailed skeleton arguments, if that will help keep matters on track.
Yes, we've only got Mr. Chezian's evidence lined up for today, is that right?
Yes.
Well, we can certainly reduce the openings, and if there's any particular point, you can have sort of 10, 15 minutes rather than 30 minutes and get back on track that way.
I'm
very
grateful,
well.
my lord.
Thank you. Now let's deal with the conflict of interest point. Mr. Kapoor, I've got your. Hold on a minute. What do you want me? What should I be looking at, Mr. Kapoor? I only received this supplementary stuff this morning or last night. I can't remember now. So what would you like me to be looking at?
Your Honor, what I've done is that I've actually tried to summarize everything in this, the de novo new application, which I have put forward to you for your review. And if I could just take you through some parts of that application, that will lay out.
This is the application notice, is that right?
Yeah, it's the 9th witness statement by me, dated 27th May 2022.
Right, hold on. Yeah. What I'm interested in is, don't worry about the formal bits. So where do I find the main grounds of complaint?
Okay, let me just open that for you.
Or would you like me to spend 5 minutes just reading it quickly, and then you can elaborate on certain points?
That will be. I'll be grateful for that, sir, because I'm not really a lawyer. I cannot present an argument as eloquently as some of the other people in the room. But if it could request you to kindly just read it for 5 minutes, it'll be really helpful.
Okay, I'm going to turn the microphone off and the picture off for a minute, and right, Mr. Kapoor.
Sir.
I've read your witness statement. This is your well, the one you showed me anyway, the supplementary one. And I understand, not expressing opinions, but I understand that you have concern about the claimant's lawyers having acted for the bank and for you in various respects in the history of this matter. That I understand. What I am not sure I understand at the moment is why you say that they're acting in that way has given them confidential information which would assist them in these proceedings, as opposed to what happened in the past. Do you understand what I mean?
Your Honor, I think I do understand a little bit about what you're saying, but maybe if you can kindly allow me to, put things into perspective in my own way.
Of course.
You could kindly then, infer from there. The problem is that when we engaged Kocher and Company, it was for the entire gamut of legal advice concerning the affairs of Velocity Group as a whole. It was not for one company, it was for everything. And as a result, a lot of information was shared. Now, if I may just kindly draw your attention to the paragraph number 21 of that statement. And if you kindly look at the timelines, right? What is apparent as from various documents, and as we go through the trial, you'll also see that basically there was a deadlock. There was a difference of opinion. There was a conflict between T5 and myself, right?
Yeah.
For whatever reasons.
Yeah.
And when we went to them, our overall perspective was that, look, as of December 2018, we had a contract available from a multinational company, which basically would have allowed the business to continue and for us to be able to meet our obligations to the bank, right? As a part of that, the most important issue was the issue of how to resolve the operation of the bank account, because the operation of the bank account was essentially, for practical purposes, one signature from myself and one from D5. The two signatures were essential for doing any transaction, and they were aware of this. In my first witness statement, when I had interjected about this conflict, the reply we got from Mrs. Khan in her witness statement was that they had only represented me in a civil case in Fujairah, and that's it, right? So none of the other things were brought out, and they never technically agreed to giving a much more comprehensive advice, right? And the irony is that the Fujairah company, which they are referring to, is actually the holding company of this matter under discussion today, which is Velocity Industries. It was when they went into the documentation of that is when they discovered that the original trade license, which included the defendants 6 to 8 also as shareholders in a collective company called Umaku, was still in force, and the new trade license or the new activity, whatever had to take place, had not been completed, and hence the company was still, as for the bank records or any other records or Dubai's legal records, could be operated by defendants 6 to 8, D4 and D5, as was the case earlier. And particular paragraph regarding this issue even during the pre-trial hearing, and we talked about how there was an advice given by them that you could use the powers vested with the old sponsor of the company to actually change the shareholding, etc. And it was outlined in an email. It was confirmed on record by their then representing counsel that they were acting on behalf of the claimant when they did that.
Mm-hmm.
Right? Now, if all this was possible, if they were aware of all this, and if all these facts they were acting on behalf of the claimant, and if all these facts had been placed with the claimant, then kindly just proceed down further in the timeline to what happened in a certain order. Like if you see by if you look at, let's look at point number 21.10, right?
Yeah.
Is where they have given a full discussion document, which is for being an active discussion between Goodwin and Kocher, which is representing D4 and D5 respectively, to see how they could find a solution to this deadlock. How could there be a settlement between the two parties? If you see the next point, on 9th of August, a draft settlement agreement is also exchanged to be discussed. It was never agreed, but it was to be discussed. On 21.12, if you see, on 3rd of September, the bank simply goes ahead and issues a final notice of default without calling for a meeting, without having a meeting with the stakeholders, without anything like that. And this is very, very unusual, because any bank, before issuing a notice of default, would call all the stakeholders to the table. And if you look at the suit itself, the defendants clearly are D1, which is Velocity Industries, LLC, D2, which is Umaku, which is the collective entity which held the interests of 6 to 8. And Velocity Ventures, which was jointly held between me and Ravi, which is D4 and D5, right? So as per their own records and as per their own existing claim, they acknowledge that this was the shareholding and these are the companies against which they're seeking restitution. Now, this point was in their knowledge. It was in the knowledge of Kocher and Company. This was in the knowledge of the bank. And at no point of time was any effort made by Kocher and Company to go and actually resolve this issue and request the bank to call for a meeting. And just kindly look at 21.14. That means on 3rd November, the bank issues a default notice. And on 29th November, the credit facility expires, unless it is renewed. And on 2nd of October 2019, I get an email from Ms. Anjali outlining a comprehensive strategy as to what we can do, how it can still be used to negotiate with the D5, how this can still be used to put the entity back on track, and how this whole thing can still lead to paying off the rent, changing the shareholding and things like that. So it's not about the confidential information in the case, but because I was taken aback when the first notice came to me, this was issued by the claimant's lawyer for me to appear in legal proceedings concerning Velocity Industries, and that's why in the very first witness statement I raised the issue of conflict of interest. So see, when it comes to my arguments or my submissions regarding the bank or the claimant, I obviously will talk about the same things that they could have given us time. They prematurely called this notice. We did all that. But what I'm absolutely not able to understand is that if they were always acting for the claimant and had information to this extent that they did not advise the claimant to even conduct a single meeting. I mean, I can understand and appreciate that after that meeting, after all the facts are placed before the table, the bank may or may not, in their own right, choose to do what they want to do. But the very fact that even that basic meeting of the minds around a table was not arranged. And thereafter, now, the same facts are being used against me as a defendant to say that I did not meet my obligations and we are at fault and we should be paying the bank back. That is my fundamental, issue of conflict. And I have further, in my own humble, submission, I have tried to summarize it, more, in a summary. If you look at point number 27 and you look at point number 27, 28, and 29, that in all these cases, the approach has been rather dismissive, If the first witness statement, I said there is a conflict of interest, I'm sorry, but I should not be casting aspersions on a court of good authority. But they could have at least said, okay, this is a matter we should, hear properly. And if you have submitted some documents in support of this, we should at least see what the objection really is. Okay, it was not done. The summary judgment was set aside. Even thereafter, whenever any witness statements were filed, I kept on repeating this plea, right? And to be honest, I am not very well versed with the proceedings the way they are conducted in a DIFC, a court and English law. But I had thought that any of these points, anytime when they are raised, somebody would at least, agree to hear it. And I'm grateful that at least in the pre-trial hearing, you said this was one of the issues which has not yet been settled and allowed me to, present the case again. So it took me some time to not only provide all the information to the other counsels who would ask access to it, but also to put it in a particular order to explain the series of events and how it happened and what transpired in my plea. And what happened after that with the registrar is something which again I have documented at the beginning of my argument.
Mr. Kapoor, you don't need to address me about what happened before the registrar, because the rules of the DIFC mean that I have to consider the matter afresh. The registrar makes a decision. If you are unhappy with that decision, you can come, you have 3 days, which you've done, you come to court and say, please reconsider it. And I don't start from the assumption the registrar was right or was wrong. I listen to the argument. So you needn't go into that aspect of it.
I appreciate, sir. My only concern by expressing that was in terms of the timelines, that we did try to meet every of these timelines. We did go through the process. And since we did not feel that we had been adequately heard, we requested you to kindly consider and look into this matter.
Okay.
So I think, given that I have already requested you to read the whole application, which you have very kindly done, and I have mentioned my concerns.
What I would like just to help for you to help me on, if you can. I understand the complaints you make, and again, I'm not saying whether they're justified or not. That's not for present purposes until I hear all parties and so on. But the complaints you make are about the conduct of the claimants' solicitors, claimants' lawyers, in acting for both the bank and for you, and as a result, giving you advice, you say, which they shouldn't have done, putting it very crudely, yeah? Because of their knowledge of, because of their involvement with you as well as with the claimants. What I have to consider for your present application is a slightly different matter. You may have a complaint about that. It can be taken up. But for the present purposes, I have to consider whether they're acting now on behalf of the bank would disadvantage you in the conduct of these proceedings because, for example, they have information which is not before the court. Because if it is before the court, it's public, and whether they should have got it or not is beside the point. But whether they have information about your approach to this litigation or about something else which will enable them to succeed in this litigation or arguably succeed when they couldn't otherwise have done. Do you understand what I'm saying?
I understand, Your Honor.
So what is your answer to that question?
My answer is that this is the whole approach, the whole sequence of events which they are aware of. In fact, that would have been my line of defense, that we had a contract, the bank did not allow us an opportunity. We could operate the account, we could have easily operated the account and conducted the business of the company, which we did not, we were not allowed to. And all this information and all these arguments are already with them. And because they were privy to it, now they are presenting the arguments on behalf of the claimant, basically, keeping this information in mind, and that is prejudicial to my interest.
All right. Well, should I hear what before I ask Ms. Khan to answer? I think the other defendants want to be involved in this discussion, and I think who appears for the second to fifth defendant? Is that you, Mr. Shaheen?
We have serious issues here regarding this conflict of interest. In fact, an application was submitted by D4 on 10th May, and we had responded on 17th May. The second application, which is now the 9th witness statement of D4, was submitted on 27th May, and we didn't have time to respond to that. But all what we had to say are pretty much stated in our reply to D4's application submitted on 17th May.
Where do I find that?
17th May application.
Your Lordship, Your Honor, it's at A1 and A58, if I'm not mistaken. No, sorry, it's at section, what do you say? Yeah, statement of the case. No, it's not. Oh God, it went in the wrong bundle. It's in the state, but you can access to it because you have the master access. So statement of the case in chronological order. So it's the D5's response to D4 date. No, that is 18 January. I don't have the one which is latest. When did you file that?
This is 17th.
Mr. Shaheen?
17th May 2022.
Which section is it in?
I don't think it was.
Sorry, it's available at K612, K620.
K.
Yes. Case 612, case 620.
I see. D2 and 5 reply to default application. Okay. So tell me, Mr. Shaheen, in a nutshell, what is your position?
Yes, Your Lordship. See, in
Would you to read this instead?
pardon me, Your Honor.
Or would you like me to read this document?
I can explain in simple terms.
Okay.
In the year 2019, the same counsel who is acting for the claimant in this case now had approached us. Now the law firm is named as Bestwin's Law Corporation, our law firm. Earlier it was Goodwin's Law Corporation. At that time, in 2019, the claimant's counsel had approached us with a proposed settlement of disputes between D4 and D5, the two individuals. And a settlement agreement was drafted, it was exchanged. We had personal meetings also with the counsels now representing the claimant. It was in 2019. So we were aware of the fact that the claimant's counsel had acted for D5, but our impression was that it was only for the limited purpose of negotiating a settlement between D4 and D5. And on behalf of D5, I personally attended those meetings. We cooperated fully, trying our best to reach a settlement. Unfortunately, it did not happen. But now, when D4 has made this submission application regarding the conflict of interest, and the documents are produced, exhibits VK1 and VK2, right? Submitted along with the application, we understand that, in fact, D4 had approached the counsel of the claimant, not just for himself, but also for D1 and D2. And it was a very wide scope of services which were to be rendered by the claimant's counsel on behalf of D1, D2, and D5. D4, sorry, D1, D2, and D4. There itself, when I'm looking at the retainer contract, the way it was proposed, I find that as self-conflicting because the claimant's counsel were to act on behalf of the company, which is D1 and D2, and at the same time act for one of the shareholders against the other shareholder, removing that shareholder from the company, defending a criminal case, defending a civil case, all this packaged in one. I was surprised to see this. There existed a serious conflict of interest. And now, on top of all this, the same counsel is appearing for the claimant after collecting all the information pertaining to the entire group. And I could be said that I don't, as DeFi, I don't have privity of contract with the claimant's counsel. So who am I to talk about conflict of interest here? But the fact of the matter is, D2, which is a separate, distinct legal entity, was also the client of the claimant's counsel at that time. And now I am representing D2 in these proceedings. So I have that privity of contract. D2's information was entirely given to the claimant's counsel at that time. I'm representing D2 now. So definitely it causes serious prejudice, serious harm to me. And I've quoted the relevant provisions of the DIFC Code of Practice, especially
where is that?
Item number 11.
Paragraph 11.
Paragraph 11. This is Rule 7, Subclause 3 of the DIFC Code's Code of Best Legal Professional Practice. 7.3 says a lawyer who has acted for a client or whose law firm has acted for a client in a matter shall not thereafter act against, shall not, is not even may not, shall not thereafter act against the client or against persons who were involved in or associated with the client in that matter in the same or any related matter. Here it is the same matter, Your Lordship. They had given legal opinion in favor of the bank. They had acted on behalf of the companies D1 and D2. They had acted on behalf of D4 against D5, collected all the confidential information, and now acting on behalf of the claimant against D1, D2, D4, and D5. Of course, D6 and D6 to D8 are also affected parties in this. I'm very reluctant to say against a learned counsel who is part of the learned legal fraternity, but unfortunately, this is very unethical and totally unacceptable.
Help me on this. I understand your point on the provisions of the code, which you've just shown me. I understand that. This would have been a point, and I think Mr. Kapoor says it as a point he raised right at the beginning. This is the point which, at the very beginning, might have justified the court in saying, you shall not act in this case for the bank against these defendants. Well, tell me this, so I'll come back to what I was saying. Is it a matter for the court, or is it a matter for complaint to the professional bodies?
It's both, yeah.
Well, I was wondering this. The reason I ask is the court is concerned to ensure a fair trial, and of course it would be unfair if for example, if the claimant's counsel or lawyers, if the claimant's lawyers were conducting the trial and were privy to confidential information of the defendants, which would enable them to gain an advantage at the trial.
Definitely.
But this is a case where 2, 3, 4 years ago, the claimant's lawyers acted on this case for the defendants as well as for the bank. And they advised the defendants in various ways, and they obtained documents and no doubt other things. But that is all before the trial. So the trial is conducted about what happened, not what anyone thought should have been advised or shouldn't have been advised. The trial is about what happened and reasons for it. And is there anything that the claimant's lawyers have gained by reason of their, you say, wrongful actions, which prevents there being a fair trial?
Yes, Your Lordship, very valid question. The approach from the claimant's counsel to me personally, as the counsel then representing D5 for the settlement negotiation, was in 2019, towards the end of 2019.
Yeah.
And this case was filed in 2020. It's not far away, it's very close, immediately after that. I was not aware, I mean, D5 and D2 were not aware that D4 had engaged the claimant's counsel for D2 and D1 as well. We were under the impression that it's for one of the shareholders, only for the purpose of facilitating an amicable settlement between the disputing shareholders. This was our impression. Now we are having access to all the retainership agreement, letter of engagement, and the correspondence between D4 and the claimant's counsel. The scope is very wide. I don't want to read and repeat everything. It covers everything under the sky as far as these two companies are concerned. So certainly the claimant's counsel had privy to all the confidential information of D1, D2, D4, and D5. And this is causing serious prejudice. This directly violates the code of practice. And that's why I stressed on the words, it is shall not. They have no option there. I did not know before they had been engaged on behalf of D2. So I could not have raised this earlier.
Mr. Shaheen, I understand the timing point and how you discovered this, that, and the other. And I understand how you say the claimant's lawyers, while acting for the claimant, for the bank before the litigation, obtained, you'd say, a lot of information which was otherwise confidential to you and the other defendants. Let's assume that is correct. This is not what this case is about. the bank has the whatever information it had. Is the continued acting of the claimant's lawyers going to cause prejudice and to the conduct of the trial, and how is that prejudice going to be caused?
Very serious prejudice, Your Lordship, because it's not a simple case where the bank had given some loan, somebody has availed that loan, and for God's sake, it has to be repaid. It's not as simple as that in this case. Here, the facility expired, and I'm representing one of the personal guarantors. So once the facility expires, the personal guarantor cannot be held liable. All the information, correspondence pertaining to this, and there was no proper renewal of the facility. I will have to go to the merits of the case if I have to explain everything. And at that time, it was only one signature which renewed the facility afterwards. After its expiry, almost 6 months gap was there. This is a major contention being raised by D6 to D8 also. And it was single signature used to renew the facility. Whereas it is clearly written in one of the legal opinion provided by the claimant's counsel itself, the power to act on behalf of D1 is jointly between D4 and D5. Now a contention is raised to the contrary. It is my contention that that renewal of facility itself is invalid because only two persons jointly could have acted on behalf of D1 to renew the facility, and whereas D5 was one of those two joint signatories, D5 did not sign. And we have serious contentions that D5's signature was digitally copied and misused throughout by D4.
But Mr. Shaheen, that surely is a defense on the merits, which you have, or it's a good defense or a bad defense, but it's a point you take in defense of the action. It doesn't matter. It doesn't weaken your point if the bank acts through the present lawyers or have different lawyers. The point is there.
It certainly weakens the position, Your Lordship, because at that time, whatever documents D2, D1 had, the bank's lawyer had access to all those documents which they are not supposed to have. If it is a different lawyer, definitely the bank would not have had access to all the internal documents of D2 and D1.
But they have access now already.
Now they already got access. That is why the whole trial is not fair.
So you're saying it's impossible now to have a fair trial, whoever acts for the bank?
It has caused serious prejudice to the defendants. Whatever damage had to cause, mostly it has already caused. The wrongful action of the claimant's counsel.
Right, okay. Thank you. Is there anything else you want to add? Wait a second. Who's that speaking? That was Ms. Khan. Mrs. Khan. I'm going to come back to you in a moment. I think the counsel for the 6 to 8 defendants, Ms. McGlone, is wanting to say something. Is that right? No, it's not Ms. McGlone. Which one of you is talking this time?
My Lord, I'm happy to assist the court on this issue. We are conscious that we are obviously not a respondent to the application. Your Lordship has been taken through the arguments and the documents which give rise to considerable concern among the parties. Not least, for example, from the 6th to 8th defendant's perspective, for example, at page I3250. There was an internal, I shall just wait for your Lordship to pull the document.
I2350.
I3250.
Hold on a second. I've got to work out which file I'm in at the moment. Sorry, just give me a second, will you? I've presently lost the. Can you help me finding the page number on the automated thing? Doesn't seem to have the usual. Right, okay, I'll have to go the wrong way around. 2350.
3250.
3250. Yeah. Yep.
This is a next page that's enclosed within a strategy note prepared by the claimant's lawyers that was provided to the fourth defendant. And this note includes within it a lot of information that is confidential to the parties, but also relates to the parties' positions, their strategies, their sort of internal dispute, how that's going to affect matters going forward, etc., etc. And Your Lordship, I've heard the comments that have been made during the course of the other party submissions. And the way I would perhaps phrase or approach the issue from D6 to D8's position is this: if we were perhaps dealing with this slightly earlier in the proceedings, the question that's often asked when one is seeking to injunct a firm of solicitors is to question whether or not they have seen the other side's privileged documents through some form of disclosure, which is likely to give them an advantage. Now, I've not had a chance to go through all the documents and cross-reference and go back and forth to see where that advantage may have arisen. But if one considers the document, for example, the strategy note at 3250, as a confidential and otherwise privileged document, arguably, we would submit that would give rise to grounds for an injunction to have prevented the claimant from acting, essentially for both the borrower and the lender. And if one sort of looks at cases where mortgage companies and the borrower, for example, has used the same firm of solicitors, and the case of Matthew and Bristol Building Society comes to mind, those are cases where the courts have always sought to injunct the solicitor from acting for both parties. And it's our submission that that is very much analogous to the situation here. And in those circumstances, and for those reasons, my lord, we do support the application being advanced by the fourth defendant.
Do you say, and what I was trying to find out for the other parties was whether, looking forward from here, it could be said that there is still access to privileged information which has not been revealed so far, because we are where we are in terms of what has been disclosed and put in bundles and so on. If it shouldn't have been there, it's too late to undo that. But in terms of looking forward, can you see any prejudice in the conduct of the case by these solicitors? Because everything they've known from the defendants is now out there. Sorry, I'm expressing it badly, but do you understand the point?
I understand. I understand, my lord. If I may just take instructions on that point, somebody's just.
Supplement and support your lordship on that question.
Mr. Shaheen, can you wait? I'll come back to you.
Definitely.
My lord, I think the point that was being made to me was exactly the same one that I was about to articulate, which is I'm grateful for the short, very short adjournment there, is that until cross-examination happens, I don't know what else is within the possession of the claimants, which may be used to the disadvantage of my clients. I appreciate that information is out there in witness statements, but the witness statements put forward by the bank are not voluminous. They don't address a number of the issues which are going to be live issues in the trial. And therefore, I'm afraid it's at this juncture, it's very hard for me to know quite what the impact will be until I hear the claimant's cross-examination.
What you're saying, the emphasis of what you're saying relates to past knowledge of privileged information, which is probably now in the bundles in the open. Is that right?
Not necessarily in the bundles, because we don't have the full file of the claimant, and therefore, to the extent that there were discussions had with the fourth defendant, which from the fourth defendant's submissions appeared to be very extensive instructions that were being provided about the first defendant, the second defendant, well, all of the defendants, how they were approaching the business, what considerations were going through their mind. I mean, we certainly see, for example, from the page that I took you to, that he was discussing the sale of the property, the sale of the company to new owners. So all of this formed part and parcel of the oral discussions that he was having. And without having seen the claimant's internal notes and memorandum, it's very hard to know what other information, which I would draw an analogy and say it's effectively similar to privileged information, is within the control, possession and mind of the claimant. And it may be, my lord, that the claimant is doing their best to try and separate these two matters, but at the end of the day, it's a very hard divide and a very hard line to draw when you're in possession of this much information, which D4 has stated he volunteered to the claimant whilst he had instructed them.
What I think your submission goes to then is to say that these lawyers shouldn't act for the bank in the present case, but nor should the bank be allowed to continue the action because there is irremediable prejudice by the disclosure of confidential information.
That would certainly be our primary submission. However, to what extent the claimant has discussed all of this with the bank, we really don't know. But yes, my lord, that would be our primary position.
Would you be able to dig out, you mentioned a case of Matthew against Bristol Building Society, and no doubt there are other authorities. And what is the principle of law in terms of the conflict of interest in terms of the conduct of litigation? Does the court have power to prevent solicitors acting in a case?
Yes, my lord, I would refer to the Ennio case, which I will also, the Ennio law case, which I will also find and send across ASAP. That was a case in which actually privileged documents had come into the possession of Ennio law, and a question had arisen as to whether or not they should be injuncted from acting for their former client. If it also assists the court, I have a judgment, albeit it's from the Guernsey courts, to do with a chambre de discipline matter, but again, that deals with the Matthews and Bristol Building Society case and why that would give rise to a conflict where the same law is effectively acting for the borrower and the lender. And I'd be happy to flag the relevant provisions and send that across to your lordship. Yeah,
because I had thought there was a distinction drawn between the prejudice caused by the solicitors having access to confidential information, for example, as to the settlement strategy of a party or something like that, and cases where the damage has in effect been done and all the documents are there, and it doesn't really matter who acts for the claimants in that sort of situation. But it may be this becomes clearer if I see those cases. If you could get them as soon as possible onto the well, if you send them to my clerk, I can, as appendices to an email, attachments to an email rather, that would, I think, be helpful. Thank you very much. Now, before I hear you, Mrs. Khan, sorry, Mr. Shaheen wanted to add something. It's better he adds it before you then have a chance to address it.
Yes, Your Lordship. First of all, can I continue?
Yes.
First of all, the trial is not over. To me, the trial may be 50% now. The remaining portion of the trial is very important, especially the cross-examination part. And when other side, the lawyer of the opposite side, has more information than what I have about my client. Regarding my client, I'm representing D2 and D5. D2, I have limited information because I have only one person who is a major shareholder of D2 with me. The other one is D4. But D4 had given all the documents pertaining to D1 and D2 to the claimant's counsel. So this is where I am. So the cross-examination will become meaningless. And now we have to go for the closing submissions, finalized skeleton arguments, everything. There is serious prejudice remaining to be caused. Irrevocable prejudice has already, irremediable prejudice has already been caused. I agree with your lordship. That's part of it. Now, the language of the legislation 7.3, a lawyer who has acted for a client or whose law firm has acted for a client in a matter shall not thereafter act against the client or against persons who were involved in or associated with the client in that matter in the same or any related matter, shall not in the same matter. This is what I take. So the prejudice is presumed by the legislation and is not a rebuttable presumption here. The presumption is there is serious prejudice and it need not be proven. We don't have to explain that when the language is so clear. We don't even have to look for any precedents here because the legislation, the text is unequivocal, unambiguous. Shall not appear. It's very clear there. And the prejudice is presumed, I repeat, it need not be proven. It's not a rebuttable presumption.
Yeah.
That's all, Your Lordship.
Yeah, thank you. Now, Mrs. Khan, it's your turn.
Thank you, Your Lordship. At the outset, if you look at the list of exhibits provided by D4, which you can easily search in the index called VK1, VK2, VK3. Primarily to consider D4 as a client, he has to pay our fees. He hasn't paid our fees. To consider D4 as our client, he has to sign our engagement letter. He hasn't signed an engagement letter. He did pay 150,000 dirhams, and we provided evidence that this money was paid to the local council who represented him. We are not an advocacy firm. So the local council took the full money. For our work where we provided corporate advice, we were not paid at all. That is one thing. Defendants,
whether or not you were paid, did you provide advice?
We provided advice for a very different matter. And we have not denied it. It is an advice and it is written in bold letters. Goal to remove D2, D5. Goal to remove D5. Goal to remove D5. That was the goal. D4 had a serious issue of the conflict with D5 and his only mission for disclosing any document or anything is how to remove D5 from the entities. That was the objective. The strategy note in bold letters is saying that. Secondly, is that the defendant, that is D4 and D5 or D2, did not provide a single evidence that we use these documents in these proceedings or any knowledge was used. Nothing. Secondly, all the emails which D4 has provided, it is already shared with D5, it is already shared with the bank. There was nothing confidential that was provided. Nothing. And we have not used it because number one is that we were retained by the claimant only for the closing argument. And that period was for a limited period. When D4 came as a client, we were not engaged by the claimant at all. D4 was there only for a limited period of 4 months, that is from May to September, where we were trying to resolve 3 issues. And we have provided in our witness statement proof that we have engaged local counsel, proof that we have paid local counsel, proof what was our scope of work, our timesheets were provided. Everything says that our whole work, corporate work, was only to remove D5 as the shareholder of the company. Now, in order to prove that they were prejudiced, D4, D5 must prove that we have used a single document. The moment D4 left UAE, we archived the file, and he knows why we did it. And we have never disclosed any single information throughout the proceedings what transpired with D4. We had archived the files. That is why there were conflicting reports by Anjali, because she said something else. We didn't have the files. When he filed the new application, we had to unarchive the file, get hold of all the documents, and that was the stage when the trial was there. So how can you say that we are going to use this information? What information you can give me pertaining to shareholders dispute? Our mandate was very clear. Shareholders dispute, getting rid of criminal cases against Mr. Kapoor in Ras Al Khaimah and Bardubai, and last is representing D4 for an expert. This has got nothing to do for a claim under facility agreement. And then he turns around and he says that, and in fact, it is not the claimant who has disclosed a document, it is D4 who has disclosed every document. He has disclosed our privilege, our confidential strategy document. It is marked there, privilege and confidential. He had no business to disclose, but he disclosed it. He is the one who disclosed the settlement agreement, not the claimant, not the claimant's counsel. So he is the one who's breaching the law. And lastly, Ms. Anjali is no longer registered with DIFC as part 1. She has resigned from the firm. She's moved to another. She's serving currently her notice period, and she's going to leave the country and move to another firm. So I don't see the purpose at the end of the trial to derail the trial, prevent us from representing the claimant when we acted for parties at different intervals.
Well, okay.
And that too for a client who did not pay us.
Whether the client
and did not sign the engagement letter.
You say you acted for a client who didn't pay you, so that confirms that you did act for him.
No, we are not denying, Your Lordship, we are not denying. But we acted different interval for a different purpose, for a different matter. It has got nothing to do with this current dispute. If D4 wants to remove Mr. Shaheen, the client of Mr. Shaheen, what sort of documents he will give me? He will give me the memorandum, he will give me the trade license. And or the resolution. What has a memorandum, trade license, resolution got to do with a facility agreement and a guarantee? Because his intention was to remove D5 from the company. That was his whole agenda. Even the settlement agreement, I believe, was for this purpose. I haven't even looked at the settlement agreement. But the fact is that the whole purpose of D4 and D5 dispute was to remove each other from the company. So what sort of documents I could get access to? What sort of information? I will only get memorandum, trade license that my client has. The claimant will have as a KYC document.
All right.
And I can prove by email that all the documents which I received in this trial were sent by the claimant. We had archived D4's file. We could not access to it because we were afraid of something, what would happen. We were afraid of the CID coming and inspecting our records. Do you want me to continue, Mr. Vijay?
No, by all means, Mrs. Khan, I have no problem. But I think
we have never disclosed why we archived the file. We never disclosed why we have stopped acting for D4. Sorry, Your Lordship. Sorry. My apologies.
I can't listen properly if you're both talking.
Sorry.
Sorry about that.
Mr. Kep, do you want to say something?
Yeah, if Mrs. Khan is finished, then probably if you give me an opportunity, I would like to respond. Yeah.
We'll wait for a moment then. Mrs. Khan, is there anything more you want to say at this stage?
No, Your Lordship, only I would request you to look at our documents and our exhibits that are marked, which will establish that what are the documents which has been.
Where do I find that?
Just 1 second. So we have the 8th witness statement, which is at G 317 and G 323. When we prepared this first witness statement of Miss Anjali, at that time also we did not have access to the file because the files were archived. So she was not sure whatever she said regarding the date, it was not accurate. But when the matter got serious and a specific application was filed on 10th of May, then we unarchived the file. That's when we unarchived the file. And on 18th May, we prepared a response with supporting documents, and that will be available at G336 and G356. And we also have exhibits which will be available in additional documents. I will have it here also. Yes, exhibit under the 9th witness statement of Anjali Shiva Ramakrishnan, that is available at K621 and K655.
Right.
You will see exactly the scope of work we have done, who was handling Mr. Kapoor's work, and what instructions were given to the local lawyer, everything. The only work which we did was the corporate work. Our timesheets are recorded. In fact, we are owed more money than what is mentioned in the invoice, and we have not been paid for it. Nevertheless, we confirm that whatever advice has been given, it's written clearly in bold letters in the strategy note, even if it is for D1, even if it is for D2, even if it is for D4, it clearly says the purpose of this advice is to remove D5 from the company. That's the only purpose. Now, Mr. Kapoor has this tendency of forwarding documents to everybody. If you see his exhibits, even if it is exhibit 13, 14, 10, it's all forwarded documents. So it's not necessary that whatever you have forwarded to us, we have acted upon it. Mr. Kapoor should, in fact, if he alleges that we have provided services on a specific document, he needs to prove if we have acted upon it. We have not acted upon it. We have not read it because he kept on dumping and bombarding documents and emails to our firm, which was outside the scope of our work. We had 3 precise scope of work: to represent him Ras Al Khaimah and Bardubai police station, for the expert appointment, and for the corporate advice to remove D5 from the company, and the settlement agreement is a part of the corporate advice. Now, what has that got to do with a litigation case under a facility agreement, under a guarantee in the present dispute? And my second question is, why at this stage? When you file an application to set aside the default judgment, you filed the application for that purpose. Conflict of interest was an excuse, but you did not file in the beginning of the trial an application to prevent the claimant's counsel from representing the claimant. You did not do that. You did it now at the end in the trial to derail the trial. And everybody are colluding with each other. I am confirming that the defendants are colluding with each other and they are constantly occupying my time and my energy. In this particular proceedings, I have almost corresponded with the defendants under 323 emails. That's the way they have worked around this whole trial, engaging me. One is sending an email, then the other is sending an email, then the other is sending an email. Then they keep on doing it all the time to keep me occupied, and I don't focus on the trial. So that's the strategy. That's a whole reason to bring this up, this issue at this date.
Right. Mr. Kapoor, you wanted to say something in response, but don't let it descend into abuse.
No, not at all, Your Honor. I'm very much conscious of the place and where I am, and I'm only going to humbly just readdress the fact that my simple understanding of the law or whatever I have, little experience I have in my 35 years of banking and as a chartered accountant, I have never had a situation, or I've never seen a situation where a lawyer who represents you in a particular case, no matter how you dissect it, left, right, and center, that this was only for this or it was only for that. She is talking about me forwarding information. Obviously, briefing the council is an important task, and all documents were supposed to be sent, which then thereafter there were series of meetings. So it was not that. As far as Anjali, whose name is being brought up as the first witness statement also, we had a meeting there, and it was very clearly agreed that I am not in a financial position to be able to pay large sums of money, and any other outside counsel or any other lawyers cannot be engaged without consulting with me. And it was actually, in fact, agreed that this 150,000 dirhams was a retainership for a period of 12 months at least. Okay, that's documented in the retainership agreement. Number two, in all these matters, when even the settlement was being discussed with D5, if somebody were to go through that settlement agreement, and maybe Mr. Shaheen, could probably interject and maybe confirm, it was clearly saying that this settlement can take place provided that we get some time to restructure P1. We get some time to go and restructure the facilities with the bank. And all the current outstandings, what was due to the bank, everything was shared, and it was shared with the council. Now, the most important part which you need to see, Your Honor, is that when the claimant has now filed this case, this whole discovery in the Dubai Economic Department that the old shareholding still stands was done by the council. In fact, they, based on that discovery, came and gave this other advice that, look, if you want to remove this deadlock, and the problem was not just removal of D5, the problem was how do we resolve the deadlock so that we can operate these entities. If you kindly look at, even in my argument, there is a separate opinion which the council has given in a related company, which is Velocity, Foods and Beverages. They've given a written opinion to the bank on how in that entity, even one signatory can operate the account, right? So the whole objective was to resolve the deadlock and move forward in operating the business, right? Now, when I first raised the issue of conflict, frankly, even if it was simply saying the fact that, okay, it was not just this, but a variety of other matters which are privileged and which we don't want to talk about, I can understand it. But the most dismissive response in the witness statement was, we only represented the client in a civil case in Fujairah. You can kindly look at their own witness statement. You can see the paragraph which clearly says that. There was no mention about anything else. There was no mention that they were retained for much larger perspective. And my point is, if there is a law firm which is very credible, which is large, which has got several offices around the world, what was the basic compulsion to go and represent the claimant when you had already represented me? And did they take a waiver? Did they take a waiver from the bank clearly that, we have been represented in D4, so are you okay that we represent you? And vice versa, did they take a waiver from me that, okay, since you have not paid, since we are terminating this thing, but we want a waiver from you that now we are free to do whatever we like as far as any cases against you are concerned. I mean, I'm talking from common sense. I'm not a lawyer. I don't know what the law says on all this, but it's very, very tragic that at various stages, in my own way, in my witness statements, I have been raising this point time and again. In fact, before we went to trial, there was a list of residual issues, and one of the issues which you quickly pointed out, saying this has still not been resolved, I think we should ask him to file an application. So the timing of the application is not for derailment of the trial. The timing of the application is not for that. I mean, frankly, the very fact that we agreed to this trial and we still came and are present here before you for whatever has to happen shows that we have no intention to avoid a trial. But please understand what Mr. Shaheen said. If I were to now cross-examine the bank and ask them, okay, look, Did the lawyer, or did your lawyer tell you that this shareholding could have been changed? Based on that, why did you not call first for a meeting? What do you think his response is going to be? He's already been tutored as to what will be asked and what he should be saying. So is that a fair trial? I mean, she says that I have been forwarding information. She's taking that they've engaged so many of these counsels. Show me one written consent of mine where I have agreed. Other than the a lawyer which was appointed for the Fujairah courts, I have not consented to anybody else being appointed. So people will present the facts based on the situation. I understand that, but I think I will only humbly submit that the fact remains that if you have represented a person, the same law firm or the same lawyer cannot go and represent anybody against the same person. And that's my understanding. Very simple. Maybe it's very elementary, but I've seen that everywhere in the world. In fact, especially in India and everywhere else, that you can never have the same counsel come and oppose you. So I will not argue on legalities. I think I'll leave it for some of my learned counsels to probably, give us some information and educate us. But my humble submission is that what is being portrayed, that this was just a simple engagement of only removing D5. It was not the case, because frankly, the whole intention was never removal of D5. The only intention was just to find an end to the deadlock so that we can keep the company as a going concern, so that we can actually run our business and pay our obligations back. And the fact that if you say that that has all happened in the past, may I humbly ask you a question, that if that point of time this was not done, then should not that be allowed us as a very single point of defense in what we are now going to face in a trial? Would the counsel be willing to come in as a witness and be examined on that point? Would the Anjali be, can she be called as a witness to understand what she should be saying? That is the whole point. I mean, with so many clients, with so many other engagements, they could have simply told the bank that, look, we cannot represent you. It's as simple as that. And I think I tend to agree with Mr. Shaheen that the rules of the DIFC or any other English jurisdiction are pretty clear on this, that a conflict is a conflict, no matter how you define it, but they should not be representing the claimant. And if I had raised the point only in the summary judgment time, I can agree. But soon after that, when the next notice came, my first interjection was the same thing again. And if we had been guided by any jurisdictional authority that, okay, could you just present this thing as a separate, argument and an application, we would have done so. We've done it even now. And for that, I can only be thankful to you that at least you allowed us an opportunity to do so.
Okay, thank you. Mr. Shaheen, you keep it short, please.
Yes, Your Lordship. My learned friend put it very simple, as if it was just a partnership dispute and she was only representing one of the partners in order to find an amicable solution to the shareholder dispute there. This was my understanding too, and that's why I did not object earlier. But now, if we look at VK1, which is I3199 in the bundle.
Hang on. I3K, sorry.
I3199 is a retainership agreement, May 27th, 2019.
I have to hold on, sorry. I31.
199.
3199.
Yes, sir.
Okay, wait a sec.
199. 199.
Oh, I199. Okay.
This is a retainership, May 27th, 2019. Here, if your Lordship may please read the second line, first and second line. We understand that Velocity has several group companies in the UAE to conduct its business operations.
I must have the wrong document. Give me the reference again.
I3199.
I3. I don't know what you mean by I3. Well, page, bundle I, page 199. Or 3199.
3199.
3199. Sorry.
Sorry, Your Lordship. I think I was not clear. This is exhibit VK1 submitted
I
along
have
with.
it.
Yes, Your Lordship. So May 27, 2019, subject is retainership. It's addressed to Mr. Vijay Kapoor. But if we read the first paragraph, we understand that Velocity has several group companies in the UAE to conduct its business operations, which are Velocity Ventures Limited, that is D2 here, Velocity Industries LLC, and Velocity Food and Beverages and other companies being part of the group, collectively referred to as the group. We have been informed that the group requires legal advice. Who requires legal advice here, Your Lordship? It's not Mr. Vijay Kapoor, it's the group, which includes D1 and D2. So the claimants counsel at that time was representing D1 and D2, not one of the shareholders, as my learned friend put it. That's first part. And then D4 just stated that the 150,000 dirham was paid towards the retainership. Here the fee quoted is 250,000, which is based on 200 hours of work at a blended discounted rate of AED 1,250 per hour. The next page, C bullet point 2. So it's very much probable what he said may be true, 150,000 paid towards this. So the retainership is there. And my learned friend said the firm was he was dumping and bombarding documents at them. So this is an admitted fact now. So they had access to almost all the documents. All the documents are sitting in their firm. They had ample opportunity to review them, and they can continue to review them because those documents are still with them. Dumping and bombarding documents was exactly the words used. I would not have been able to say this without her statement. Now, I-3202.
Yeah.
I-3202.
Yeah.
That's a letter dated 9 June 2019 from the Claimants Council. Vijay Kapoor, Managing Partner, Velocity Ventures Limited is the addressee. Dear Mr. Kapoor, thank you for considering our firm to represent Velocity Ventures FZZ. That's D2. Velocity Ventures Limited, Velocity Ventures FZZ. I'm a bit confused. I don't know which one it is. In connection with a claim filed by Ravi, which is D5 for case number. Again, Claimants Council was representing the company Velocity Ventures, which I understand is D2. Is not representing an individual, as my learned friend tried to put it very lightly. That's not the case. And the allegation about trying to derail the trial, I think it fits much better to the Claimants Council. Such an allegation should not have been raised against us. We are here to participate in the trial. When the Claimants Council has submitted application, their counsel is withdrawn, they are not ready, and this is not the first time. And if at all somebody is derailing the trial at this stage, they should have thought of this at the time of accepting to act as the counsel for the claimant in the case, not now.
Yeah.
They were aware of all the facts, not me. I came to know about this engagement and the fact that they had acted for D2, who's my client now, only when I saw claimant's application on 10th May 2022. To which I responded promptly within the time allowed on 17th May 2022. Now another application, the 9th witness statement has been submitted by D4, which has come on 27th May, day before yesterday. I didn't have enough time to respond to that. And I would certainly love to respond to this now. So it's not a simple case. It's a very, very serious conflict of interest which has been created. It's a presumption, a firm presumption under the legislation. And the legislation is very clear, unambiguous language, shall not represent, shall not appear. It's very clear. It's not a rebuttable presumption, I repeat. And I don't have to prove any prejudice. Prejudice is presumed, and that is why the legislative provision is so firm and strict on it. And everything has been admitted now, being dumped and bombarded with documents. Retainership in the name of the companies, directly D2, contrary to what my learned friend submitted before the Honorable Court. D1 and D2, not only D2.
Thank you.
Thank you, Lordship.
Your Lordship, I know this has gone too long for too long. We have actually two SMS to Mr. Kapoor, where our firm has approached Miss Anjali has approached Mr. Kapoor, asking him that we have been retained by the claimant now. What do you want to do? So if a person is being asked for a consent and he refuses to give, he refuses to pay us, a retainership has not been signed, what choice that leaves us? So it's not that we acted unilaterally and just jumped from one fence to the other. We did inform him. We did seek his consent. He refused to give. He always kept on evading, I will call you, I will call you.
You asked for his consent, but he refused to give it.
Means he just evaded. He didn't say no, he didn't say yes. If you look at the SMS on the last page, I can guide you to it.
Which
Please.
page is that?
Just one minute. Yes, there are two SMS between Miss Anjali. It is at K 654 and 655.
Right, hold on. Six 654 and 655.
Yes, there are two SMS where we have expressed the need that we have been approached by the bank. We need to speak to you. And this was discussed, and Anjali Shivaraman Krishnan has affirmed in a witness statement that D4 verbally did give his consent, and now he's denying. Unfortunately, she relied on this trust, she relied on his words, but she is willing to confirm on oath that he did give his consent.
Sorry, I've got the, which message is it?
It's at K 654 and K 655.
Which is the one?
Yeah, it's the whole WhatsApp screenshot. Hi, I guess you're busy. We need to understand what you're intending on doing. The bank wants to initiate legal case against Velocity. We need to speak urgently on this matter. Yes, I will connect later today, and then he discusses something else. Then she also says you need to pay our invoice for the work done. Local counsel needs to be paid. No response. Then on the next day, on the next page, that is K655, it says the expert hearing is for the Fujairah case fix for 19. Please clear the invoice. Okay, we spent so much time and effort, provided detailed timesheet. There is no response from your side for the payment. Please have this done today. Anjali, let us discuss this properly. We have made substantial payment to you as well at the beginning, based on trust and judicious use of the limited funds. Now, without understanding that if we have to engage local counsel and we are not an advocacy firm, then we have to pay them money. Okay, and then it continues that let me know a good time to call. We can provide full details of the funds utilized. Hiring criminal and civil lawyers is expensive. We can call tomorrow. And at this call, when Mr. Vijay Kapoor spoke to Ms. Anjali, he confirmed that I don't have funds to pay. You may go ahead and represent the bank. And she had specified this in her witness statement, affirmed it as an oath that this is what he said.
Give me the reference to that in her witness statement.
Just one second. It's at witness statement number 2, or her second witness statement.
Just where's that?
Just bear with me, please. Okay, it's at paragraph 41, G, paragraph 41, G 346.
Paragraph what? 31.
41. G 346. In my last telephone call with D4, under the aforesaid chat messages, I solemnly affirm that Vijay Kapoor, the fourth defendant, also said that he was agreeable for us to continue to act as the lender's counsel and initiate action against the borrower and the guarantors under the instructions of the claimant. Now, if a person has given an affirmed statement under a witness statement, she is speaking the truth.
Well, that is, it'll be surprising though to be content with an oral confirmation on an important matter like that.
Well, she trusted him and she brought up the topic, but they never reached the stage. And then finally, Mr. Kapoor started avoiding her because she kept on chasing for the payment. And this is what she mentioned in the witness statement also.
Okay.
So obviously, he's not going to give anything in return. And that's the reason that he is very upset with her. I can understand that. But the fact is now she's no longer associated with the firm. She's on her way out. She's no longer DIFC practitioners to apply any rules. And I don't see where we are going to go after exercising so much time and effort on this trial, just to set it aside at this stage.
Right.
And your lordship, we do have a problem, as rightly pointed out by Ms. Askarian. We do need permission of the court, and this will be applicable for all the defendants because I understand that even D6 and 7 are in India, and even if we bring our defendants here, this is a procedure that has to be followed. The courts of Dubai have to write to the courts of India, and this is going to be a long drawn process.
So, sorry, are you telling me, or back on the previous matter, you do require
Yes.
permission from the Indian court?
Yes, we have checked it with our counsel, Mr. Kunal, and he has confirmed that the courts of Dubai have to write to the courts of India. Now, if this diplomatic channel is exercised at this stage, it's going to be a long drawn process.
And if it's not exercised, what happens then?
Nothing.
May I just add to what Mrs. Khan said?
Okay, yes, yeah.
May I just add to what Mrs. Khan said? Only parts that we need to really examine is that if we get the witnesses into Dubai, whether we would breach that clause, and that's just being examined by the team in India, and we would need a little more time to just examine that during the course of today.
We've got a witness due on at
Mr. Cheesian.
12:50 UK time, 15:50 Dubai time. Is that witness going to appear?
Well, he's ready to appear online, but if this is going to be raised and eventually his witness statement is going to be set aside.
It's not a question of it being raised. It's a question of what you ought to have done before arranging for him to give evidence from India.
Well, we were not aware of this.
Well, you were. The point was raised with you, as I understand it, if only about 2 days ago, and you said there's no problem.
Yeah, because that's what the confirmation we received from the claimant's lawyers. But now Mr. Vajani has checked it and he has confirmed, and we have come forward and said that yes, that's true, that has to be done.
So what are you suggesting happens?
So now we will find out whether they can come here and solve the problem, because if that's the issue, that will be for even D6 and D8, because they are also currently in India. They're Indian citizens.
Yes, but hang on a second. If you don't call any evidence, they don't need to bother.
They are submitting. In fact, Mr. Jitendra Maniram's evidence is very important because that pertains to the claim amount. But Mr. Cheesian and Mr. Kumar are for periods that have been cleared. The claim amount has been cleared.
No, but excuse me, Mrs. Khan, you're a claimant. You have to prove your case.
Yes.
You need witnesses to prove your case.
True.
Those witnesses cannot presently give evidence from India, so they cannot give evidence at 15:50 UAE time, your witness is due to give evidence. He can't. What are you asking for? If he doesn't give evidence and the other witnesses don't give evidence, then there's no need for the defendants to worry about evidence. So what are you asking?
That we will come to know only when Mr. Vajani confirms that if they come to Dubai, can this problem be solved?
Well, can they be in Dubai by 1550?
No, impossible.
Okay, so what about a practical suggestion?
We postpone it by half a day. They will come tonight and appear tomorrow.
Right, that's your
As
suggestion.
it is, we are behind schedule for our work, and it's just one statement from, we can carry it on tomorrow and manage to squeeze in.
Right. Well, what do the other parties say about that? Let's take it in turn and try and get in a proper order. Mr. Shaheen. What do you say?
I thought I need to complete the issue of conflict of interest. There was something brought up new saying waiver by D4. Even if there was a waiver by D4, assuming without admitting, that doesn't apply to D2.
Okay, I understand that.
Plus, it is very clear from the SMS messages produced that they were aware of the conflict. They were concerned about the conflict. Despite that, they did not take a written waiver. That's also admitted now.
Yeah,
Even if,
Your Honor, I never gave any waiver, just for the record. I never gave any such waiver.
I understand your point on that.
so those 2 points are to be noted, Your Lordship. One is they were aware of a conflict. Despite being fully aware of a conflict, they did not take a proper written waiver. One, even assuming that a witness statement, sworn statement is enough to show that there was a waiver, despite it being denied by the other side, it doesn't apply to D2. I represent D2 in this case.
Yeah, okay. Thank you. Let's come back to, I think we've probably had enough on the conflict point for the moment. Let's come back to this point about the witnesses. You've given your position. You suggest, Ms. Khan, that we start your witnesses from Dubai tomorrow. Is that right?
Yes.
That's an application you make then to adjourn now so that your witness can be heard first thing tomorrow morning from Dubai.
Yes. They will come tonight.
And
Just arranging the visa.
And you are confident about, you're willing to pay whatever expenses are necessary for the adjournment. Well, either you are or you aren't. If a party,
But the court can also decide that we will do the needful and they will be there. I mean, they can do the hearing today as scheduled.
Can they?
I mean, online, and then they will come tomorrow, and that can be affirmed, or we can. It's a discretion of the court.
I didn't understand what you're saying. You told me, with the advice from your co-counsel, that these witnesses need the permission of the Indian authorities before they can give evidence from India. They're due to give evidence from India this afternoon. One of them is. Are you asking for an adjournment so that that witness can be heard tomorrow morning instead of this afternoon? If
or
that
they can carry on with the evidence today. And,
how?
I mean, online, the way it was planned.
But I thought you've accepted now they can't do that.
I mean, that's.
Sorry, I need to get clear submissions from you.
Well, this is something which has been raised again, and if we were aware of this before the trial, we would have made arrangement because I'm not well versed with Indian laws that is required. I'm based in Dubai and not. I've left India long back. So,
Mrs. Khan, you've told me what you understand to be the position now. It needs permission from the Indian authorities.
We will need 1 hour to confirm that if they come here, that is going to resolve the matter, or we still need permission. We need 1 hour.
Well, you can. I'll hear from the other parties. Mr. Shaheen first. Do you have anything you want to say?
I would prefer D6 to D8's counsel represent the matter first because they raised this issue.
So you prefer what?
D6 to D8, their counsel raised this issue, so I would prefer that she handles this part.
Let's carry on. Apparently you're right.
I'm grateful to my learned friend. My lord, our observations are as follows. In terms of our witnesses, obviously subject to the point that your lordship raised that we won't need to call them if the bank doesn't call its witnesses. They are actually parties to the proceeding and they have submitted to the jurisdiction of the court. Therefore, we say that there is a difference between them and a witness giving evidence. But putting that to one side, in terms of the practical solution proposed by the court, we don't have any. We don't object to that, save that we would raise two matters. The first is that we would like some assurance that, given that it's about 4 p.m. in India, that the witnesses will be able to get the relevant visas and travel permits that they need to come to Dubai, and that there is definitely a flight going tonight that will get them here on time. The second observation, my lord, is that owing to counsel and KBH and the witnesses' other prior commitments, the trial does need to be concluded by Friday, and we're now going to lose an afternoon of cross-examination by reason of the delay. But subject to those observations, my lord, we don't have any objections to the practical solution posed by the claimant.
The practical solution being?
If they can get their witnesses here on time, but also that the trial will conclude by Friday.
Right. It's quite tight anyway, the trial schedule.
Sorry.
Right. Mr. Kapoor, do you want to add anything? I don't think you're involved in this matter, are you?
Not really technically qualified to comment on something like this, and my stance remains that we should decide the all-important issue of conflict as well, because that is going to be integral to the rest of the trial, sir.
Okay. Mr. Shaheen, do you want to say anything about the witnesses?
I support what D4 said and also what counsel to D6 to D8 said. Nothing more to add. Conflict is to be resolved and it has to happen as D6 to D8 counsel said. Logistics.
Mrs. Khan, I think we need to know within the next hour or so what the position is. Mrs. Khan?
Yes, Your Lordship. I'm just coordinating, and I will get back to you on this. But if there is a situation that the visa will take long, then we are going to be helpless in this circumstances, and we will have to wait till the visa is processed. Because whatever has transpired regarding this rule, when one of the lawyer confirmed that there's no such requirement, we relied on that information, and this is what has happened. But if it is required, then the visa will take time, and
then you'll be an adjournment, will you? Then you will be asking for an adjournment.
Yes.
With the usual consequences.
They are very happy, of course, but I don't know if it is postponed also by 2 days. In case the visa takes 2 days, then what is going to be the cost? I need to know the cost because I need approval of the claimants board, and I don't see they have any choice if that's the case. And we will exercise all this effort only if we know that even if they come here, Mr. Bajani can help me out in this because I'm not well versed with Indian laws.
No, so I seek your pardon, Judge, to add to what Mrs. Khan is saying, that we'll try and see if we can, within the next 1 hour, get a solution on the legal position that if they come here, it resolves the problem legally. Second, added to it, also a practical position to what Mrs. Asgharian said, is to see how practically it is possible for their travel documentation to be endorsed so that they can be here for the time scheduled, which is 12 noon Dubai time. Both counts, if your lordships can give us an hour, it's about 14:30 hours, 14:40 rather, in Dubai, and we try and come back by 15:30 hours before your lordships so that we have some clear answers to give. In the meantime, as Mrs. Khan said, that we would need also to put the client and the bank to notice as to what is the cost that will entail if this is adjourned, and that's if some clarity is spelled out on that front, because all the approvals can then come in one go and a considered decision can be taken.
Well, I think all I can say about costs is that the usual consequence of applying for an adjournment is that you pay the costs of the adjournment caused by the adjournment. And normally that would involve the, for example, if the adjournment meant the case didn't finish by the end of Friday, then it would require further time, further expense in preparation and so on. But I can't give you any. You'll have to ask other parties for an estimate or for an indication. But you have to give your advice to your client without any advice from me, I'm afraid, on that. But I need to know when you come back, if you are asking for an adjournment and it carries with it the obligation to pay the costs caused by the adjournment, then you need to be clear whether you still apply for an adjournment on that basis. Do you understand? Indeed. Very well. Well, shall we then stop now for, it's probably about lunchtime anyway. Shall we adjourn now until 12:40 UK time, 15:40 Dubai time, and
Your Lordship, I would add also one more thing, that if all this is true and the requirement is required, then whatever D4 has said now will not be applicable, will not be considered, because he also cannot come. He also needs permission. Whatever he said, whatever he contended, should be struck off.
He hasn't given evidence yet.
He has contended and he has supported with his witness statement. Whatever he's contended, he has guided you to those documents.
Yes. All right.
Thank you.
You want everyone, all the evidence from India to be struck out. Think carefully about it.
I mean,
right.
This is his statement. We are making arrangement, we are making costs, and we are going to pay cost, and we are going to do the needful. So if that's the case, then where does Mr. Vijay Kapoor stands?
I think before we resume, if you're able to get instructions and discuss it with other parties, that will also be helpful. But if not, we'll resume anyway at 12:40 UK time, 15:40 Dubai time.
Okay.
Right.
Thank you.
Thank you very much.
Thank you.
Good afternoon. Is everyone present? Who is not here? Mr. Kapoor is not here.
I'm here, Your Honor.
You are here.
Yeah, we just had a temporary setback. We had a huge storm outside, so we just had to rush out to take care of the car.
Just one second, Mr. Cheeson, you have to just log off or log in when you're called, not now. Okay, thank you. Please disconnect.
Right, Mrs. Khan, where have we got to? I can't hear you. You're muted, I think.
I'm sorry. I said we have a resolution and we have nothing to be concerned about. Mr. Vajani will explain.
Yes. Judge, we've re-examined the whole position, and it seems to be a clear situation of a red herring. We've taken full assistance and gone back on the entire jurisprudence on the provisions that were cited, as well as examined the 1999 treaty, which was entered between UAE and India. And cumulatively, all those provisions reflect that these are provisions which are facilitatory in nature, solely to provide where the witnesses cannot be produced before a particular court in which the proceedings are on. Then on commission, their evidences are taken in the local courts. So these are provisions which facilitate only those positions that witnesses who can't be produced before the court of competent jurisdiction, the court in which they reside will appoint commissions to take evidence so that that evidence can go to the foreign courts. And for that purpose is to prove that that evidence goes to the foreign court, a letter of request is a documentary position that is required, or a party can make that request. In these proceedings, as we see, the witness statements are before the DIFC court, and the witnesses who are our employees who have at the relevant point of time been working within the jurisdiction of DIFC and are going to depose only on matters of their working within the jurisdiction of DIFC are appearing before your lordships and available for cross-examination by all counsel on the evidence that they lead before your lordship. And therefore, in this situation, those provisions are not applicable or do not need to raise any source of concern for continuation of these proceedings in a timely manner right from 1550 hours this afternoon.
Right. Ms. Asgharian, you are the one that raised this point. Are you content with that?
And sorry, before Mrs. Karin starts, our client, Mr. Jitendra Maniram, sorry, with the permission of the court. Mr. Maniram has already given witness being in India for a DIFC matter, and no such protocol was followed or it was required.
Right.
I can give the case reference also.
Thank you. Mrs. Asgharian.
My lord, it seems to me from the explanation that has been given that there has been a conflation or eliding of an issue where one takes a deposition from somebody who is based in India versus the situation of a witness giving evidence to a foreign court. And that it was the former position that my learned friend Mr. Vajani appeared to be addressing and not the current position. However, in order to follow the court's guidance that was provided earlier this morning, we would nonetheless still request that a formal witness evidence or statement or some sort be given so that we may review precisely what's being said and just check the validity of the matter. As we still maintain, this is an important issue that does need to be properly looked into.
And meanwhile, do we?
And meanwhile, well then, my lord, we can proceed on the basis that he suggested this morning, which is that the evidence be given, but still that the direction stands that the claimant ought to file evidence to support the position.
Yeah. Very well. Any objection to that, Mr. Vajani? That we leave the evidence in accordance with the timetable, but that in the meantime you set out in writing the evidence that of Indian law that you've been talking about, so that the other side, the defendants, can consider it, and if necessary, ask the court to make a ruling.
Very well. We will respond to then the supplementary skeleton arguments with whatever we need to support with it. And in the meantime, the matters can proceed so that eventually, if there is still a conflict that exists, then Ms. Asgharian can request the court to humbly rule upon the same.
Yes. And when can you do that skeleton by?
Since we would now be completely embroiled with the evidence that is to go on for the course of the week, I think if we may given time during the course of next week to file whatever we need to respond to those.
I think I don't see why, if you've got if you have the information to hand, I don't see why it can't be produced by tomorrow.
This is the interpretation and the oral advice that we have received. We'll get together concrete evidence, or if there is any supporting ruling to that effect. We don't want to give, since it's a conflicting issue, Mrs. Garland is not accepting my statement at the outset, and it still remains open as a conflicting issue. It would be better and the court may be then subsequently called upon to rule on the same. It may be better that we support ourselves if there is any further rulings to this effect, or if there is any further documentary evidence that we have. This 1 hour exercise that we carried out during the break was sort of to aid that the proceedings do not get derailed if we were seeing a real red flag on the other side. Since there is no real red flag on the other side, and that's the comfort that we've achieved, we will compile whatever we need to put on record to respond to this supplementary, which we've received on Saturday, just this Saturday itself. So I will beseech your lordships to consider giving us little adequate time considering that, we've had a situation where we had a lead counsel who dropped out. I'm sort of, trying to aid and take over this position overnight. And Ms. Khan is, being embroiled in all of this now alone. So we'll try and get things together, even probably by the end of the week. But I didn't want to commit to that, considering that we have a strict timeline.
I understand. I understand the practical difficulties you have, but I think it would be useful for me to have the information by the end of the week, at least.
We will try to put that together for your lordships.
Not a question of trying. If we can have the information by the end of the week,
then we would. since I'll take that as a direction, and we would.
Yes, thank you, Ms. Asghari. I think that's as far as we can take it at the moment, and you'll have an opportunity once you've seen the written material to comment. And what I've said before would apply, that if it turns out that the witnesses could not properly give evidence from India, then the consequence would be that their evidence is to be, as it were, removed from the proceedings. And the same would apply, of course, to any other witnesses.
My Lord, we're most grateful for the indication.
Very well. What I'm going to do about the other matter, the conflict of interest matter, is to proceed for present purposes. I'll give a decision, a formal decision tomorrow, but it's a matter on which I may, thank you, by the way, for sending me the authorities, but it's a decision which is not entirely straightforward, but I'll give you my ruling tomorrow morning, but it may be followed by more detailed reasons later, which I need to consider the authorities and some of the material before committing to paper. So I may produce a separate written judgment on that point. But for the moment, we'll proceed. And the next stage, therefore, is, where are we time-wise on the program? It is 15:50, is it? Dubai time?
It is, my Lord.
1 minute before 15:50.
We would be, at this stage, going to call the evidence of Mr. Chezian. Is there anything else that needs to be dealt with before that, or are we going to, do you want to make oral submissions, opening submissions, or do you want to skip that?
My Lord, if I may jump in at this point.
Yes, of course, yes.
I'm very grateful. Given that much of today thus far has been taken up with various procedural matters,
Yes.
and although I bear in mind the timetable, I would request that we provide some relatively short opening submissions if your lordship is agreeable to that.
Yes, when you say short, do you mean shorter than the 30 minutes or following the...
Quite possibly shorter than 30 minutes. I, for my part, shall certainly endeavour to cut those down so that they're well accommodated within that.
And what is, if necessary, not start Mr. Chezian until, well, I suppose until tomorrow then? Or would he start a bit later in the afternoon, maybe?
That would certainly be my proposal. My Lord, I'm conscious that others are dialing in from Dubai where the time is slightly later. And so others may wish to also make submissions on that point. But I personally would be happy to address Mr. Chezian later on today.
Yes. Ms. Khan, the suggestion is that we follow the approach in the timetable of having short opening submissions. You don't, of course, need to add anything if you don't want to at this stage. But I think the suggestion is that we follow that approach and then call Mr. Chezian after that. Are you happy with that?
Your Honor, we could start with the opening with, I think what Ms. Askarian has said is that, yes, it has been covered, and for me, it has been written by somebody who did not turn up today, and to step into a shoe and my way of course, I'm ready as such, that's not a problem there, but there are certain issues I need to clarify. But I don't see that we can complete Mr. Chazin's statement today because of the timetable that was scheduled for his cross-examination. So he will have to either do a bit today and the rest later on tomorrow. Because we just have 2 hours now.
Yes, well, we can have we can have short opening submissions followed by Mr. Chezian's evidence to start and complete tomorrow. I think that's probably the best thing. How long do you think you'd be with your opening submissions?
Well, I just need to cover a few aspects of the UAE law, and I should be able to finish it just to understand if all of us are going to follow an equal opening statement, then even 30 minutes was definitely less for the 50 pages prepared by Ms. Justina. So I don't know. I mean, we could just carry on with the opening and have the witness statement done tomorrow itself.
Well,
because we have 2 hours now, so.
The opening submissions are not meant to be a full repetition of the written argument. It's only if you want to focus on particular matters or highlight particular matters. Yeah, you don't have to, of course. You can take it, just leave it with your written submissions if you prefer.
Sure, then I will just address 2 issues which are not covered in my skeleton, which are important and that needs to be addressed on the UAE law and the issue of the plant and machinery, and that's it. And I rest on what has been written.
Yeah.
For your consideration. But I need 5 minutes to compose myself because I shut every window. It was too many windows that opened for the conflict of interest. So I need 5 minutes.
All right. If we'll proceed on, if everyone just disconnects, or don't disconnect, in fact, just mute yourselves for 5 minutes, and you will come back on in 5 minutes' time. Thank you.
I'm ready.
Right. Are all the other parties there? Where's Mr. Kapoor? Is he there? Right. Is that everyone we need? Very well. Yeah. Mrs. Khan.
This one. In the skeleton argument of D6 to D8, D6 and D8 have referenced a new article 1061 of the Civil Code. Now, what does 1061 of the Civil Code essentially says in a very simple and straightforward language, which is definitely not expressed in LexisNexis or any other, that you must first establish your debt against a judgment debtor and then initiate a suit against the guarantors upon his failure to pay. So if we go and understand this, what essentially D6 and D8 are contending is that we should first file a claim against D1, and if he fails to pay, then file another lawsuit, incur another additional expense, and file a case against the guarantors. Well, if we would have done this, it definitely does not meet the court's overriding objective of wasting court's time and resources. And secondly, we have complied with Article 1094 of the Civil Code, which says that if a claim is filed against the surety, he must ask for forced intervention of the principal, failing which the principal may avail of himself to rebut the debtor's claim. So Article 1094 says essentially that all parties can be made a party to a proceedings. Similarly, we have another defense against this article of 1061, that is Article 1078, which says a creditor may have a claim against the principal and or the surety. That's the first article of 1078. So the bank or the claimant has exercised this requirement of saving time, cost, and resources by making all the parties a party to this proceedings. The claimant has served the claim formally on D1. D1 authorized representative, that is a manager of the company, Mr. Ravi Kuchimanji, has received the claim through the official deputation by Tabligh, and these points have been addressed in my submissions. Now, the second point has been raised frequently by D5 and D2 on the bank's initiative of not saving the plant and machinery. Now, this particular issue has been addressed extensively, and there are certain evidences that are mentioned therein, but it is under a response of the claimant under the request for information raised by D6 to D8. This document is available at section F, and it runs from page 145. I can just give you the completing reference. 145 to F156, and the evidence related to this request response of the claimant to the request for information is also available at F157 to 184. Now, in my response, in particular, the allegation that the claimant failed to save the plant and machinery, the fact is that, first of all, it is not the claimant's obligation to pay the lease of a premises that is supposed to be paid by the defendant, that is D1. The claimant was informed that there were meeting and discussion held with DIFC, that is the Dubai Industrial City, the government authority. The claimant did try its best to facilitate and mediate the matter. And on 17 September, this is referenced on page F150. On 17 September, DIFC wrote to
F what?
F150.
Yeah. Yeah, sorry, Karen.
Yeah, so on 17 September, DIC wrote to D5 that pursuant to the meeting held on 13 September, these are the amounts that are due. 6 months rent had to be paid, bounce checks amount had to be paid, litigation fee had to be paid, auction fee had to be paid, and we go to the next pages, they have listed a list of costs that had to be paid. And they made it very clear that if these amounts were not going to be settled, then the plant will be auctioned. Now, the claimant at that point of time, we are talking about 17 September 2020, the claimant had already filed CFI 25-2020 on 17 March 2020. Upon receiving the default judgment on 17 September, incidentally the same date, the claimant filed an application to amend the name of 8 defendants. Now, if under the UAE law, if you have a judgment, it is very easy to enforce it. So the claimant thought that when they will get the default judgment, they will enforce the judgment by attaching the property of D1, and that's the way that they could have, saved the plant and machinery. But the D4 and D6 and 8 filed an application to set aside the default judgment, and consequently, the claimant had to refile the case, submit, and this process has been continued to date. So now, in good faith, claimant tried to mitigate the matter and assured DIC that the rent will be settled. But when the claimant, being a public sector undertaking, approached his committee, the committee refused to give permission because the first reason is that the account was already NPA. Secondly, the case was already filed. And third is that the claimant did not want to take the risk of filing further proceedings and incurring cost, especially against a government entity. Now, the fact I'm mentioning about a government entity is under the rules of the Civil Code, Article 513, and this article is referenced at page 152. Under Article 513, any dues that shall be paid out of a sale proceeds of a property encumbered with its privilege, in whatever hands it may be, and before any other right, whether privileged or secured by mortgage, the right of the government will be first. So the claimant knew that even if it exercises the effort of, because this property was also pledged under an asset. So the claimant knew that if we would spend the money, and it's not that straightforward self-help remedy, like my learned friend said, you have to file an application before the magistrate of a summary execution. You have to contend that this is your right. And there will be an opportunity for the other party to object. And if the court feels that the objection is valid, then the other party will win. So the claimant knew that since it's a government entity, the chances of winning the case would be very less. The government will have first priority of the property, and that is the reason the plant and machinery was sold and auctioned in favor of the government. The second point raised by the defendants is that it was sold at an undervalue or undervalue level, and because the claimant failed to mitigate the matter and it failed to exercise self-help remedies. I've already explained that self-help remedies is not simple that I go and tell DIC that you cannot take this asset because it belongs to me and I have a charge. No, I have to file an application. I have to engage a lawyer, and there will be a hearing, there will be a session, there will be an objection by the other party. The D6 and D8 are not aware how an auction process takes place. In the Dubai Code, a property cannot be sold under auction unless a reserve price is set. A reserve price is set only when 3 experts, court-appointed experts, evaluate the property and an average value is taken. Now, paragraph 24, I have explained the process followed by the court to reduce. Paragraph 24 at page 152, F152. Because I have personally done mortgage, so I am aware of this sale by auction. So when the property cannot be sold for any reason whatsoever, you may not have a buyer, the buyer does not find the price fit or the reserve price fit, which was set by 3 experts, the Emirates auction will apply to the execution judge for a decision to re-auction the collateral at consecutive session with a reduced price of 5% over 5 sessions. And after reducing 25%, if there is no bidding done, then it is put up for auction after few months. So every reduction, MRIS auction has to seek the permission of the court, reducing it gradually till a buyer purchases the property for the collateral. So if the property, the process of doing it is so long that it is the claimant's contention that D1 had time, the D1's promoter had time to arrange an investor which they had promised and to settle the lease, but it failed. So the authorized representative of D1 were in fact breach of the obligation. They had an obligation under the mortgage of movables which was signed. It is referenced at H529. Under that agreement of mortgage over movable, Articles 6D and 5 says that the claimant, that is D1, is liable for cost and consequences, and they are liable to pay the renewal, the fees, the agency fees. That is their obligation. So if they have failed to do so, they cannot turn around and blame the claimant that the claimant failed to prevent the sale of plant and machinery, and therefore they are liable and not the claimant. Now, and the claimant has also submitted evidence in this request for information. I will let you know at page F157. At page F157, the email from Dubai Industrial City is marked to Vijay Kapoor, Ravi Kuchimanji, that is D4 and D5, and also D7 and also D6. So this means they were aware of what was happening and they were aware that this is a requirement, and the full chain of email is mentioned there, where DIFC is clearly saying that unless the debt which is required to be paid will not be paid, they will take over the property. And again, the claimant reiterates that payment of the rent is not an obligation of the claimant under the facility agreement. And we did not receive any documents of the auction except the eviction notice which is attached to this. All other correspondence were marked to the promoters because under the Dubai Civil Procedure Code, any correspondence related to the court is always marked to the manager of the company or the owners of the company if the court has their email address, but not to the claimant. So I just want to address this point, and coming back to my request for information, which is a very important document. In this document at page 153, I also address the issue that when the account is classified as non-performance NPA, what is the protocol followed? Why the bank has to carry out, from the first default, declare the account as NPA within 90 days, because the claimant is an Indian bank, and under the DFSA rule, it is allowed to follow the policies and procedures of their home country. The claimant follows the asset classification process, and that has been attached as evidence. We have also referenced article that which is available on page F154, which says that when an asset should be classified as non-performance, and we also addressed an issue which has been repeatedly raised by the defendant, that why did the bank agree or continue with the utilization request, especially when the account was defaulting, or especially when the account, the defendants did not provide the review documents. So under Article 13.3, such accounts are classified accounts with temporary deficiency, and the claimant has around 180 days to give an opportunity to the parties to rectify the mistake and to do the needful and this continuous support of the claimant so that the company does not come to a standstill. So that is the reason the facilities were, the utilization request was continued so that it does not hamper the operation of the defendant. And I also would like another issue raised by the defendants where they are alleging, especially D4, D2 and D5 is alleging that there are certain transactions that have been carried out, and the defendant does not understand that the claim of the claimant is not related to those transactions at that point of time. The claim of the claimant is only for specific 4 transactions, which I can read it out to you. They are at I3187 to I3093, and then we have, just let me see if I'm correct.
3093.
Yeah, I just want to read my, because I cannot understand my handwriting now. It's very easy. In the trial bundle, you type the word O space S space T space R, and you will get those 4 transactions that have been are the ones which are currently the matter in dispute. So if you see the trial bundle at the index also, it is I3087 to I3093. It pertains to a utilization request dated 6 December 2018. And we have the next transaction, which is I3160 to I3167. It pertains to a utilization request of 13 March 2019. Now, in this particular utilization request, if I may guide the judge, is that, Your Honor, that the request was made for a higher amount. It was the utilization request, that is I31060 and I3167. That's the reference. It was a utilization request for Synergia General Trading, and the amount requested was $237,000. But the claimant sanctioned only $90,000, and the remarks are mentioned on the document. And the reason why the claimant sanctioned only $90,000 because that was the only limit available. So the claimant did not exceed granting the utilization requests for amount more than what is allowed. So we have only 4 major transactions, which I repeat, it is at I3087 to I3093 for $542,000. The other second one is I3160 to I3167, where the requested amount was $237,000, but the claimant sanctioned only $90,000, and it was on 13th March 2019. And the third transaction, that is I3180 to I3187, it was for around $157,000, which was sanctioned or requested on 18th April 2019. Now, these 3 utilization requests, we have the original documents duly signed by D4 and D5. We have requested the parties, of course, at a very short notice, but I had mentioned it in my statement of defense at G. I can tell you the reference, letting the party know that I have the originals with me, but none of the parties came forward. It's mentioned in my request to, I have mentioned it to the parties that I have the original, but none of the parties came forward and said that we want to verify the signature. This is not my signature. This is a digital signature. Now, the claim amount pertains to this 4 transaction, and the 4th transaction is I3189 to I3196 for $620,000, which was released on requested on 20th May 2019. But this particular request was signed only by D4. Now, I have come across a document which is around 200 and at page I220 page, where the audited report is also signed by D200. Sorry, 2020. Where the audited report is only signed by D4 and not by D5, while both of them claim that they are joint authorized signatories. So under the circumstances, and we have also email correspondence in the year from 2018 to 2019, where D1 is officially using the email address to request utilization request. So number one, to discuss on this topic, is that the utilization request for these amount in dispute, we have the original. We have offered it to the parties to come and inspect. The parties did not come forward and anytime engage a signature expert to confirm whether the signature was forged or it was digital. But we, in our eyes, because the documents are signed with a ball pen and ball pens are not considered to be a digital signature, especially D5 signature was signed by a ball pen. And to date, if we want, we can hand over the documents, these particular 4 transactions to the court, that the court can see for itself that it is signed by a ball pen. And all of the transaction, all of the disputes with the defendants are raising that it is digital signature, it is not signed for the relevant period. It is already cleared, it is already paid, it is already settled. Only these 4 transactions are the ones which are in dispute, and we have provided also a table at I-3513. Which evidences that these are the 4 transactions that are disputed, that are not returned or paid to the claimant. All others have been cleared. So I don't see the point of raising an issue that the transaction for the period before this was not authorized by D5, or it was done colluding with one another company. Another important evidence that I have come across, and fortunately for us, it was D4 who had disclosed these documents in his expert when he was requested whatever documents he was required to disclose to the expert, he should disclose it to the parties. So when he disclosed his document, I came across a very interesting document which I want to bring it to the attention of the court. Just 1 second, please. It is at page K 183 to 184. Now, if we go to this page 183 to 184, which I would like to visit now also.
So K183.
Yes. Yes, I'm here at K183, but actually the email is at, in reality, the email is at K184 and 185. Here, this is an email which is sent by somebody called Pink Star. No, this email is sent by Talal Kazim, SME. And if you Google or search Talal Kazim, it turns out to be he's a banker. And he forwarded this document to somebody called Pink Star. And Pink Star forwarded this document to D7 and D6. And D6 then forwarded this document to D4 and D5. Now, this document is a list of suppliers that are restricted for LC and TR. And below that, at page K185, there are a list of suppliers that are restricted for local bill discounting, LBD. Now, in this list, these are the entities which you should not deal with. And they came to know about this list in the year 2015. And now to turn around and allege that the utilization requests were made to entities which are flagged or which are related to the parties. All these, we will share in our closing opinion that where the utilization request was pertaining to which supplier. And you will know that most of these entities have been a supplier in the history of the company or the defendant. They are the suppliers of the defendant. So my question to D1 is that if you knew that these entities are restricted, then why did you deal with them? The bank did not know this. The bank carried out its due diligence. And in our closing submission, we will also list the due diligence carried out by bank by the claimant for each transaction. We have paid heavy subscription amount to World Check, where we have carried out the due diligence of all the suppliers. And we have gradually improved our due diligence by checking the background history. So in our records, and they are attached to the utilization request. So whenever the utilization request is carried out, The claimant did verify the authenticity of this transaction, the background information of the supplier, but after looking at K184 and 185, my question is that the defendants colluded with each other to defraud the bank, ensure that the transaction is carried out between these entities, probably that to switch, if you want an LC, you go to the list of LBD or LBD to this. The fact is that when you knew these entries are restricted, why did you deal with them? I can straight away name because I have prepared the utilization request worksheet, and Al-Nada International SZ CO was a flagged entity, and we have supplied, the defendants have carried out transaction with them. We have CPL also is one of the flagged entities where the utilization request was carried out on behalf of D1. So the hands of the defendants are definitely not clean. They were hand in glove with these suppliers, and they continue to do transaction with these suppliers in spite of knowing that they are restricted by the banks. That's all I have to say. Thank you so much.
Thank you. Right. Before we go on to the next opening, which I think will be the D2 and D5, Mr. Shaheen, I suppose you want to have an opening of some sort? You're muted. Mr.
Yes.
Shaheen. How long do you think you're going to be?
15 to 30 minutes.
Okay. What we'll do is we'll because this morning has gone rather interrupted. We're going to have quarter of an hour before you start that. So we'll adjourn now till 13:45, which is 16:45.
Yes.
And then we'll resume then. Thank you. Is everyone back? Just before we resume, can I say this, that tomorrow morning the timetable has us starting at 12, in fact 12 every day. Would it be possible for parties and witnesses to be available to start at 11 Dubai time, or is that difficult? It's just tomorrow I have something which I'd like to be finished promptly at 2 UK time rather than 3. But if it can't be done, so be it. Perhaps rather than give me an answer now, just parties could check that there's no difficulty.
My lord, for the 6th to 8th defendants part, that works for both me and for Ms. Asgharian.
Good, thank you.
I'm okay with that. Tomorrow, 11 o'clock, UAE time.
Thank you very much. Mrs. Khan?
I believe Mr. Vajani, who will take over, will have no issue, and he has also confirmed that's not a problem.
Thank you. And Mr. Kapoor?
Yeah,
Is that all right with you? Thank you very much. Mr. Shaheen, I think it's your go.
So, first of all, I would like to make it clear that we have serious objection regarding the trial. The trial is not fair because the claimant's counsel is seriously conflicted and rights are fully reserved. Based on that, we proceed. I understand that your lordship will be passing an order tomorrow, but as of today, we don't have an order. So I'm constrained to make this reservation today.
I'll take that as read, that you object on that basis.
Yes, your lordship. So without prejudice to that objection, I'm submitting. Yep. The claimant did not submit the chronology of the events. So I thought it may be convenient if I do that, although it's not my admission, but the claimant's allegations. It was in 25th November 2017, the facility agreement was signed, although the effective date was June. 12 June 2017 was the effective date. and the duration of the facility was 1 year. However, the signature was on 25th November 2017. The facility amount aggregated to $10,440,000 US. These documents are H334 to H410 in the hearing bundle.
Yeah.
And incidentally, I may state here that this is the only document which has been signed by any of the defendants which can be called a facility agreement. No other document has been signed. The document on which the claimant is relying now for the purpose of this case has not been signed by anybody from the side of the defendants. The second and third defendants, D2 and D3, are corporate guarantors under the 2017 facility agreement, H411 and H434. I'm representing D2, not D3.
Sorry, give me those again, those references again.
H411 and H434.
Yeah, and
I'm
you're saying
representing
about
D2. I'm not representing D3. I'm not representing D1 either. D1 is not represented here.
yeah.
Now, D4 to D8 are the personal guarantors. H452 to 468. All these personal guarantees are signed with respect to the facility agreement that was signed on 25th November 2017, and all the personal guarantees were signed on the same date. The facility agreement dated 25th November 2017 did contemplate personal guarantees of D4 to D8 and corporate guarantees of D2 and D3. On 3rd September 2019, the bank issued a recall notice against D1. The recall notices were sent to the corporate guarantors and personal guarantors as well. This is I3223 and I3237, or I3223 to I3237. On 17th March 2020, the claim was lodged before the Honorable DIFC Court, holding D1 to D8 jointly and severally responsible to pay an amount of $2,403,037 and cents 16. $2,403,037 and cents 16. Now, the first argument that we are raising on behalf of D2 and D5, and the same arguments have been raised by D6 to D8 as well, is that the facility agreement terminated on 12th June 2018. It expired. The 2017 facility agreement, which is H335, clause 2.4, is very clear in this respect. It's page number H347. Two 2.4 reads, on or before the end of each annual review, the lender will confirm to the borrower whether or not the facility is to be made available to the borrower following such annual review. So a conscious decision has to be taken or had to be taken on or before the expiry date, which was 12 June 2018. whether the borrower will be continued to avail the facilities. If the lender does not confirm to the borrower that the facility is to be made available after the annual review, it's not that if it confirms it will not allow. If it is not confirmed that it will continue to allow. That is a negative clause there. The borrower may no longer make any utilization available after the annual review. Utilization remaining under the facility and all outstanding balances under the facility are to be paid on the respective due dates. Meaning, if there is no renewal, if there is no confirmation from the claimant to the borrower that the facility is renewed, the facility is no longer available to the borrower, and the entire facility has to be repaid. The borrower shall submit a detailed proposal in advance at least 3 months prior to the expiry of the facility, and the lender shall send its recommendations at least 45 days before the expiry of the facility. Nothing happened. The bank does not have a case that somebody submitted an application or a proposal 3 months prior to the expiry date of the facility, nor does the bank have a case that they had sent its recommendation 45 days before the expiry of the facility. So the fact remains, the facilities granted under the 2017 facility agreement effectively expired on 12 June 2018.
Right.
So I repeat, there is no contemporaneous evidence to support the bank's case. If at all the bank wants to argue, there is nothing to support such argument that the bank undertook a review on or before 12 June 2018 and agreed to extend the term of the 2017 facility agreement, or Velocity International Logistics, what is it? VIL, Velocity Industries Limited, that is the borrower had requested for an extension of the term on or before 12 June 2018, or critically that bank agreed to extend the 2017 facility agreement on or before 12 June 2018. There was no review, there was no request, there was no confirmation of approval of renewal of the facility. None of the three happened. So if the claimant of its own volition and without any authorized request from D1 and or without putting D1 on notice to that effect, on or about 15 November 2018, the bank is sending a memorandum, the claimant bank is sending a memorandum to its management committee, credit approval committee.
So what date was that? What date was that?
I-2975 to I-3008. I-2975 to I-3008, 15th November 2018.
Yeah.
The bank is sending its more an internal communication, a memorandum to its own management or the credit approval committee, seeking a renewal of D1's credit facilities. You cannot blow life to a dead body. The facility had effectively expired on 12 June 2018. And then the bank sending this internal communication months later, seeking approval for renewal of the facilities, it doesn't make sense at all. It's of no consequences. It's of no effect. The memorandum, when reviewed with the bank's asset classification policy, clearly demonstrates that 2000 facility agreement had not been extended on or before 12 June 2018. And owing to the distressed status of the account, it was stated that any further lending would require a new facility agreement and new personal guarantees. New facility agreement and new personal guarantees. This is what is stated there. The bank has classified the account as SMA2. This is I-2976. SMA2, in other words, it was a non-performing asset NPA. The bank was of the view that the D1 is having its own bank, its sole banking with us, and that the operation of its account is not satisfactory. The account is in stress since October 2017. This is I-2981. All these discussions are about a facility.
2981.
2981, yes, Your Lordship. All these are bank's internal discussions about a facility which had already expired months ago. Now, clause 26.1 of the 2017 facility agreement. Any communication to be made under or in connection with the finance document shall be in writing. The bank has failed to provide any evidence to demonstrate that on or before 12 June 2018, the 2017 facility agreement had been renewed for a further year and that it had communicated its decision to D1 and the personal guarantors in writing. There is no such case for the bank. Bank doesn't even argue that they communicated something in writing before 12 June 2018. Such renewal has happened. And the facility agreement mandates that any communication has to be in writing. And the bank is an authorized firm regulated by the DFSA. It works in DIFC, so DFSA regulates it. Is required to observe high level of integrity and owes a duty of care, skill, and diligence to its customers. Even otherwise, internationally accepted practice under the banker-customer relationship, the bank is the expert. The customer or whoever it is considered to be a layman. So bank has got extra duty of care. The principle governing the relationship should be utmost good faith, aberime fide. The only communication here was on 5th January 2019. When the claimant issued a new sanction letter that was drawn up, the 2019 January sanction letter, I-3137 to I-3140, I believe. The offering up to provide credit facilities D1 until 5th December 2019.
Yep.
So the bank was fully aware that the credit facility agreement had expired and it acknowledged the expiry, invalidity of the 2017 facility agreement by issuing a new facility agreement in the year 2019. The 2019 January sanction letter was sanction letter. Sorry, it was not a facility agreement. Was based on a letter from D1 in December 2018. I-3007 and 3008. Requesting reallotment of overall limit of the overdraft facility. D1 had submitted a request. Allotment of overall limit of the overdraft facility. But it is very pertinent to note here. This letter was signed only by one person who is D4 and never by D5. Any representation on behalf of D1 ought to have been by joint signatures of D4 and D5, who are the shareholders. And this fact has come out. It is a resolution of the documents which I have produced. I'll take your lordship through that. But even when we were looking at the conflict issue, the notes provided by the claimant's counsel, I-3217, item number 6 attached to that retainership agreement, Velocity Industries LLC Dubai. This is D1. 6th line, financial and administrative rights, jointly by VK and Ravi. VK is Vijay Kapoor, Ravi is Ravi Kuchimanchi. VK is D4 and Ravi is D5. So they have written for themselves and addressed to D4, who was their client at that time. It requires double joint signatures, any financial or administrative matter. Again, an issue of conflict of interest, why it is causing prejudice here. They have verified all that. They have seen documents. I don't know what documents were dumped and bombarded to them by D4 at that time. So I'm just touching upon the conflict of interest once more here. Now, as per the director's resolution of D1, dated 17th March 2014, which was submitted to the claimant bank. That's 173 to I-73 and 74. Sorry, I-73 and 74. Director's resolution of D1, I-73 and 74. D4 is not authorized to act unilaterally on any authority and requires the combined authorization of both D4 and D5. This is my whole case here. The 2019 facility, the request for allotment went in December 2018. It was not binding on D1. Though I'm not representing D1, I'm unable to represent D1 because it requires the double signature of D4 and D5 who are not in talking terms. So I couldn't get a power of attorney or an instruction to represent D1 here, nor could anybody else. So D1 could not have requested for this allotment limit for the overdraft facility that was sanctioned by 2019 facility agreement or the sanction letter by the single signature of D4 alone. And that has been admitted in the internal note or the legal opinion given by the claimant's counsel to D4, which I just referred to now while discussing the conflict of interest, their own legal opinion. D5 was not even aware of this letter, this request for allotment in December 2018. D5 had no information about it, went behind the back of D5, who had no idea about this. So I conclude on that this request of D1 purportedly to be on behalf of D1 is completely unauthorized, and the claimant should not have accepted this request. And that's just the beginning. Anything happening after that, all the utilization requests, everything has been signed mostly by D4 alone. And it's not I wouldn't call it a digital signature the way they put it in the correspondence. It's actually electronically copy pasted signature of D5, what was being used regularly by D4. Despite the fact that D5 had clearly warned D4 to stop this practice. 6 months regularly, D5 had communicated to the bank, the claimant, stop doing this. Don't accept this. Don't allow this online transactions. Please insist on my physical signature. Serious disputes were going on between D4 and D5 at that time regarding the operations of the company. Very serious criminal allegations were there against D4. And they were not just allegations. Subsequently, criminal cases were filed and judgment has been issued convicting D4 for having committed such fraudulent activities. We have produced those documents before the court. I'll come to that. And in the 2019 January sanction letter, there is a very specific requirement to be signed by D1 and the personal guarantors also as an acknowledgement that they have understood and accepted the terms. This was the requirement even for the personal guarantors. Nobody has ever signed those terms or accepted those terms. And from 12th June 2018, the date of expiry of the 2017 facility agreement, and thereafter until 19 May 2019, the bank continued to allow D1 to borrow money, presumably from its overdraft facility and the term loans that had already expired, which were signed by one person alone, that was D4. And despite the letters written to the claimant by D5, setting out the misuse of such signatures, electronically copied signatures. I'm hesitant to call it digital signatures, though we have also used the same language since that was the way it was addressed in all the communications. So that much about the facility agreement. We have a claimant before this honorable court coming with a facility agreement or a sanction letter which is not signed by anybody else other than the bank. The only document which was signed in 2017 had long expired also, without any claim being raised under that. Now coming to the recall notices issued. There was no cure period. There is no event of default clearly stated there. It is in violation of the 2017 facility agreement, but they could not have issued the default notice under 2017 facility agreement because that had expired long back. And they were considering issuance of another facility agreement by the sanction letter in January 2019. Again, Your Lordship, these are areas where the internal. Sorry,
I didn't catch that. You broke up.
This is again, Your Lordship, again an area where the internal communications between D4, D5 pertaining to D2, D1 have all been disclosed to the Claimants Council, which is my understanding. When the Claimants Council was hired by D4 to act on behalf of D1, D2, and D4. Serious prejudice is being caused, already caused, the damage is already done. We are all denied of the opportunity of having a fair trial here. And my sincere view is that we are only halfway through. 50% of the trial is still remaining. We are only crossed the submission stage. The effective trial is yet to happen with the examination of witnesses, cross-examination of witnesses, final closing submissions, whether it be verbal or written. So we still have some time to salvage the situation. And the personal guarantees issued are unenforceable under the UAE law. First of all, my learned friend quoted Article 513 from the UAE Civil Transaction Law. Article 513 of the Civil Transaction Law, which is UAE Federal Law number 5 of 1985. It says if the price is deferred or payable in installments, the seller may stipulate that the transfer of ownership to the purchaser be suspended until he pays the whole price, notwithstanding that the goods have been delivered. Subclause 2, if the price is paid in full, the transfer of ownership to the purchaser shall operate retrospectively of the time of the sale. I know why Your Lordship is wondering what is the relevance here. That's exactly what I'm wondering too. This was submitted, quoted 513 when she was referring to the auction done by DIC. It has nothing to do with the instant case, Your Lordship. This is all coming under effects of sale, obligations of the seller, and transfer of ownership under the contract provisions under the Civil Transaction Law. It has nothing to do with a lending relationship or a guarantee being submitted. So that's my humble submission, absolutely irrelevant, 513, unless it is 513 of some other law. I understand what my learned friend quoted is Civil Transaction Law, Article 513. Now, coming to Article 1061, it was not quoted in the right way. So I would like to invite Your Lordship's kind attention to Article 1061.
Where do I find that?
It's the law I'm quoting. Should I submit it?
Well, if you have it,
We can submit. It has been referred to in the submissions. But I don't think we have quoted, we have not produced the law as such. I'll just read it, but I will submit it within maybe a few minutes.
Well, I'll tell you what, don't submit it in a few minutes, but if overnight you can amplify the authorities part of the bundle by putting the relevant provisions from C law.
We'll produce the articles. Article 1061 was not quoted in the right way. So I'm reading it. In order for the suretyship to be valid, suretyship is guaranteed to be valid. The principal debtor must be indebted to the obligee, must be indebted to the creditor. I would read it. This is a translation. In respect of a debt or property or a known person, and it should be within the capacity of the surety to discharge the obligations. There are few conditions to be met for a guarantee to be valid. First of all, there should be a debt. The principal debtor should be known, the creditor should be known, and it should be for a known debt, and it should be within the capacity of the personal guarantor to discharge such obligations. There are 5 conditions to be met under Article 1061 for a guarantee to be valid. And the reason I'm quoting Article 1061 in the correct perspective is that the personal guarantee forms clearly says that these guarantees are governed by UAE law. And when we refer to UAE law, we should have referred to UAE Commercial Transaction Law, Law number 18 of 1993. But unfortunately, the Commercial Transaction Law does not contain any provision with respect to guarantees. So according to Article 2 of the Commercial Transaction Law, when there is no provision in the Commercial Transaction Law, reference has to be made to the Civil Transaction Law. And Civil Transaction Laws, Law number 5 of 1985, which I am quoting now, Article 1061, very clearly states that these are the conditions to be met. So on November 2017, 25/11/2018, I'm sorry, 25 November 2018, when the personal guarantees were perpetually signed, there was no debt. The facility agreement had already expired. Then to give a blanket coverage by saying that any debt that may arise in the future, this is completely against the law. The law very clearly stipulates that there has to be a known debt, a known debtor and a known creditor, and it should be for a specific amount. And it should be within the capacity of the surety, the guarantor, to discharge such debt. None of the conditions were met when the 25 November 2018 guarantee was signed. That's a major difficulty the claimant is going to face if the claimant has to enforce the guarantee under the laws of UAE. Guarantee specifically says that it is governed by the laws of UAE. Yes, Your Lordship, it may be helpful, but I'll resubmit it because it's a translation. There could be slight variations. D6 to D8 has submitted Article 1061 as A1010. The document number is A1010.
Thank you.
Thank you. And now I reiterate that the 2017 facility agreement had expired. So Article 1099 of the Civil Transaction Law, I'll submit everything together, Your Lordship. Guarantee or suretyship, the language used here is suretyship, what is meant is guarantee, shall terminate as follows. A, by discharge of the debt. B, by the loss of the thing held by the person for whom he stands surety by reason of force majeure and before a claim is made. C, by the cessation of the contract by virtue of which the right against the principal obliger arose. I don't want to read D to H, though they may be slightly relevant, but the direct one is Article 1099, subclause C, the cessation of the contract by virtue of which the right against the principal obliger arose. The principal obliger here is D1, and the principal obligation is the facility availed to be repaid. The document under which that obligation remains was the facility agreement dated 2017 that had expired even before the issuance of the guarantee. The guarantee was issued only on 25 November 2018, where the facility expired on 12 June 2018. Article 1099 has also been introduced by D6 to D8, document number A1013.
Thank you.
One more article I may invoke. There is a limitation period prescribed under the laws of UAE. The period within which a guarantee has to be invoked. It's not forever. Article 1092. If a debt is due, the creditor must claim for it within 6 months from the date which it fell due. Otherwise, the surety shall be deemed to have been discharged. So within 6 months from the debt, when the date on which the debt falling due, if the creditor does not raise a claim with the guarantor is exonerated, fully discharged of the liability, and the creditor will have no remedy whatsoever against the guarantor. Here the clear case is the 2017 facility agreement by virtue of clause 2.4. I read it in detail for Your Lordship. It clearly stated that it will be due for payment. on the expiry date if it is not otherwise notified. So it was due for payment on 12th June 2018. The guarantee itself is being signed after almost 5 months or more than that. The guarantee is invalid for that reason. Even assuming without admitting for whatever reason, if we consider that the guarantee is valid for a moment, till it is unenforceable, it's barred by limitation. There are provisions inserted in the guarantee to the effect that this limitation period is not applicable, but it's not for the parties to decide which limitation period applies. The contract has to be within the frame of law. The contract cannot be outside the frame of law. You cannot take away a limitation period, which is a mandatory stipulation under the substantive law of UAE. So that's why the 2017 facility agreement was not renewed and the personal agreement guarantees stand cancelled. And the claimant bank completely violating the bank operating mandates, which is, as admitted by the claimant's counsel, it always required the double joint signatures of D4 and D5. Most of the documents, utilization request, everything was signed only by D4. And most of the time, electronically copied signature of D5, despite D5 specifically notifying D4 and also the bank authorities, the officials, they misused it. That's why the D5's expert report has pointed out it is so suspiciously similar or exactly the same, because two signatures will never look exactly the same in the normal course. Here everything is copy pasted, that's why it's looking exactly the same. All the signatures of D5. And the originals have not, despite this contention being raised by D5 from day one before this honorable court, the originals of those documents have not been produced before the court for verification. Now, just 2 days before the trial started, learned counsel comes and says they are kept in my bank for your verification. It's not for me to go after them to their bank to verify those documents. Those documents ought to have been produced before the court for everybody's verification. We could have verified the original documents, if at all such an original document ever existed. You cannot say I've kept it home, you can come and review it there. That's not the right way. Now, failure to meet, so that much about the validity of the guarantee, that much about the misutilization of facilities, how D4 and some of the officers of the claimant acted hand in glove in order to abuse the rights and also embezzle funds to the complete disadvantage of D1, D2, D5 and all others. Substantial amounts were siphoned out of the company and the bank facilitated that. That's the only reason why this case had to be filed before the honorable court. Had they been diligent, the money would have been utilized for the intended purposes. It would not have been lost. The company would not have collapsed like this. It was the bank's mistake, basically, and D4 took advantage of that. And the cases were filed against D4. I'm repeating, judgments have been issued in the criminal case, convicting D4 to undergo imprisonment. Judgments have been issued in civil cases. Everything has been produced before the honorable court. There's one more latest judgment which came on 23rd May, holding D4 liable to pay 8 million dirhams to D5. The most recent one by Court of First Instance in Fujairah. The lawsuit number 620 of 2021. That also I'll be producing as and when required. But this is just recent development. I could not have produced it earlier. Judgments have been issued. It's not allegations. It's not just a case has been filed, judged already, fully, finally. Now, coming to the fact, the failure to mitigate the losses. It is to counter this allegation, my learned friend quoted that Article 513, which I read has no relevance at all to the instant case. As rightly stated by the counsel for D6 to D8 in the submissions, the claimant enjoyed 2 pledges over the machineries, plants, and assets of D1. The 2015 pledge, which is H147 to H182, and the 2018 pledge, which is H529 to 537. So the first charge, enforceable first charge, was created in favor of the claimant. I understand the landlord has a priority right, but even the priority right would come after the charge created. Priority rights need to be looked into only when the ownership is clear, unencumbered. Here there is a clear encumbrance. Two pledges, effective pledges created in favor of claimant. They did not bother to enforce the pledge and waived it off. Despite continuous regular requests being made by D5, please take care. It is your asset, it's your security. It is for this particular facility. It has been pledged in your favor. It'll all go for a song now. DIC is taking action. And don't tell me DIC is government. It's an entity, a corporation created by the government. Doesn't mean that it is government by itself. It's a landlord-tenant relationship what exists. A landlord can file a case, and it was a small rent, maybe maximum $200,000 to be paid, nothing more than that. And for that, the assets valued at more than $3 million, if I remember it right, $3.9 million, it went for that. Auctioned for 25% of the price as admitted by the claimant bank itself. Who is to be blamed, Your Lordship? You had sufficient security in the form of a registered pledge in your favor, two, not one. And the guarantor being afraid, I signed a personal guarantor once upon a time, even if you invoke that I don't want to be responsible. I had signed on behalf of D1 in 2017, though the facility expired. I still warn you, I instruct you, I request you, authorize you, please do something. Please do something. Don't let this go in an auction for a song. It's a valid security you have. The liability, even now, in this claim is only $2.4 million. The asset worth $3.9 million thrown in the drain without any justification, just because there was a partnership dispute between D4 and D5. They could not act together. They could not have done anything together in the name of D1. Criminal cases were filed and judged. Civil cases were pending. D4 is absconding. He's not in the country. Though his immigration status shows that he's in UAE, today he's saying that he's sitting in India. How on earth he reached India, I don't know. His immigration status is still showing that his presence is in UAE. Dubai has a law which says that if the foreign partner is outside the country, it's not a law, but the procedure, the custom followed by the Department of Economic Development, and it is written, they insist on writing it in most of the memorandums of association of the limited liability companies incorporated in the mainland. If the expatriate partner is outside the country for more than 6 months, the UAE national shareholder can own his shares. It will be transferred without a judicial process. In order to protect the employees, in order to protect the remaining assets in the company, the trend was there, the expatriate businessmen coming here and taking the flight. So in order to curtail this, the government of Dubai, they started this practice. We tried to utilize this on behalf of the UAE national shareholder in one of the companies, which is not party to this dispute, but they said the immigration status shows that D4 is still in the country. You prove that he is outside the country. How am I going to prove this? When somebody has left the country by illegal means. So how do we act together? It was an impossibility. And D4 was meeting the representatives of the claimant bank in India. We requested the bank, please record his presence and tell us. Not willing to do that also. So to their own peril, they spoiled the security. They spoiled the business. They refused to act on time, and completely everything went down the drain. And now coming to invoke personal guarantees wrongfully obtained without any basis, even if it had some basis, already expired and barred by the period of limitation. And your lordship knows better than me how they are conducting the trial. Counsels withdrawing, last minute applications. This is what we are being dragged through. So civil and criminal cases also I briefly touched upon. I think I'm taking my time. So
I think you've rather exceeded the 30 minutes.
So I'm sorry, I will not elaborate. I have submitted all those details. I have the list of the criminal cases, civil cases which are being judged. And we have an additional claim against D4 also. I'll just sum up in one line. So our request, the claim what we have against D4 is not fully quantified. So our request is to the Honorable Court is to appoint an expert in order to quantify that claim and allow us to recover that amount from D4, and alternatively hold D4 liable to indemnify us in case if the personal guarantee is enforced for whatever reason, and for all the losses suffered by us due to his own misdeeds. And as regards the additional claims submitted by D6 and D8, they have no means, they can only claim it against two people who are the real shareholders, registered shareholders of the company, who are acting on behalf of the company. But D6 to D8, I'm sure they are also aware of the innocence of D5, because D5 did not promise anything to them. It was D4 promising them, you just sign this paper, you are exiting the company. Now the new funder at DUVAT, ADUIVAT, I don't know how exactly to pronounce that, is coming in. They're taking over the full responsibility. So you will be exonerated. You just sign these papers and go, rest I will take care. That's how D6 to D8 have been taken for a ride. They had signed a guarantee in the meantime when they wanted to enter the company.
Mr. Shaheen, you can leave D6 to D8 to be represented by their own counsel.
There is a problem. They are raising a claim against D5 and D6. So I have to fix it to D4 and D5. So I have to fix that claim on D4. D5 is innocent of whatever D6 to D8 has to claim as additional claim. That's all, Your Lordship. I'm concluding my submission.
Thank you very much.
Thank you very much.
Now, next to go is Mr. Kapoor. You're as the fourth defendant. Do you want a short break before you start, or are you happy to go straight on? You're muted. Mr. Kapoor.
Yes, please.
Hey.
No, I think in the interest of time, and since we have been trying to squeeze things in, I don't mind having a short opening statement from my side as well right away without taking a break. I think the points which have been raised up till now, especially the technical points, I will not repeat them, especially what the blanks claims are, how the facility agreement expired, and how these things were not renewed, or the claims which have been made. I go back to the very basic principle of fairness and equity. It is not unusual in such conflicting scenarios where a person is painted with a bad brush, given somebody's own convenience. So in my various witness statements and in various submissions in the past, I have clearly brought out the fact that it was not just me, but the employees of the company, other partners, other people who had been having a problem with the defendant number 5, not coming to the office or not attending to his duties, etc. So we will cover that maybe when we come to the cross-examination or other issues. But I think most important is the fact of what we had highlighted, or we started with the day with, which is the conflict of interest. And if you see, when you ask me specifically that, in what way these documents or some things, could be misused or used against you, and you can clearly see that the amount of documents which have been submitted and given, the number of emails which were shared, etc. It clearly brings out that there is a lot of information which the claimant's lawyer was, aware of or had handy. And then in the normal course, had it been any other counsel or any other law firm, or they would not had all this information, then they have not been able to use it against me. Second thing is that if you look at the sequence of events, which I have earlier also elaborated, even also in the course of my earlier application for review, which you kindly took 10-15 minutes to read, it is very clear that the whole issue with the company was the case of a deadlock. There was absolutely a case of standstill. People were not able to conduct business as normal. With one partner, D5, not even coming to the office or not attending the affairs, with bankers trying to stress upon you that, look, there is a situation, we are not seeing the kind of turnover which should be happening in the company, what's going on. And this is where I bring you back again to the point of the 3rd September 2019 notice which was issued by the bank recalling the facility, right? Much before that, in December 2018, we had gone and met the bank, shared with them that there is a new agreement which is possible to be signed with a multinational company, but the problem is we cannot operate the account. Now, if you look at the suit filed or the claim filed by the claimant, it clearly acknowledges that the shareholders were, of D1 were D2 and D3. And as per the mandate and as per the signature records given to them very clearly, it required that four people had the powers to sign. 2 people in one part and 2 people in another part. So myself, which is D4, and D5 were in 2 separate parts. Along with that, D7 and D6 were in 2 separate parts. That means any 2 people could sign and operate the account. Now, out of that situation, if they had already discovered, and at least the claimant's counsel had already discovered that that was the case, the legal position of the company was still that the old shareholders and their mandates and their signatures were valid. It is amazing. It is really surprising to see that the bank never allowed the account to be conducted. Number 2, they did not call for any meetings or did not provide any cure period, did not actually call for a meeting of all stakeholders whom they were to eventually hold jointly and severally liable. Because even if that one single meeting had happened, it would have cleared up the air in front of everybody that who the signatories are, what exactly can be done, what exactly cannot be done, and the business would not have gone into its state of distress. As far as this period of even when they were talking about them exiting, when they came and signed the original MOU and they got their part money because the balance 10% was to be paid at the time of the notary, there's a considerable time of almost 1 year for which the D5 did not even agree to come to the notary to sign, having signed the original MOU in original and having paid the money to the defendant 6 to 8. And thereafter also, when I clearly told them that, look, there has to be certain other processes which have to be done, which need to be completed before the transfer takes place. Those transfers did not happen. So if you think about this in a logical manner, everybody was basically looking after their own interest. As far as the bank is concerned, okay, we gave you the money, now it's your problem to pay us. As far as we are concerned, we are not going to do whatever is in our part. We are not going to, allow you to operate the account. We are not going to facilitate. We are not going to call for any meetings. We are not going to do any kind of a resolution meeting. We are not even going to extend the courtesy of at least, exchanging an email outlining this whole thing to all of them, saying, okay, this is what we see. These are the mandates on our record. And if you guys could, get together and come back to us, what could your proposal plan is? None of that. T5, anyway, I've explained and I've submitted many emails in my this thing that was hardly available. As far as 6 to 8 were concerned, they were only interested that they've collected their money, they've got paid. And as far as the legal formalities are concerned, something which is not completed is not their problem. Now, they are qualified people, especially D7 being a person who's a banker, who's head of operations and risk at a bank, not realizing that unless these formalities are completed and the ownership is properly transferred or the bank agrees to any new owners or new guarantors, it will not be happening on its own. It's very, very simple, which is known to everybody. So I was surprised to see some allegations that whether I gave them this assurance that, okay, you just sign this and you'll be out, it doesn't work like that. And if I was talking to somebody who was not literate or somebody who was not an experienced businessman, I can still probably give them the benefit of doubt, but that was not the case in this situation. And another thing is that as far as this civil and criminal cases which keep getting referred to are concerned, I had actually requested my law firm, the ones who have been at least filing all the documents with the registry on my behalf, Al-Banna, that please check up if there are any pending litigations, because I had already started hearing rumors of these kind of things happening against me. And I have a certificate issued by the law firm that after checking all the records of all the courts, specifically with respect to Russell Khema and Fujairah, that there are no cases against me. And I have that certificate in writing, which I can, produce and show it to you. So as far as these orders are concerned, they were all ex-party orders. I do not know how this was done and how it was conducted. I never got a single notice. I never got any kind of communication from any of the courts to appear or before any of the experts to go and actually meet them or submit any documents. None of that. So I think the whole thing about these criminal cases and embezzlement is just a lot of basically throwing sand in the air and trying to see where it would stick. As far as our claim, as far as the bank is concerned, is very clear that essentially, if there was a facility which was taken, we would like that if there was a facility which had to be repaid back, if there was a notice of recall, provide a cure period, listen to the arguments. And I think this is where I again come back to the point that the claimant's counsel was fully aware that there is a mandate of 4 people to sign for this facility and conduct the business of the company. This is something which they had shared with us, but they do not. I do not know whether they shared it with the bank or the claimant, whether the claimant disregarded whatever they said, or for what reason. Even after the facility expired, I got an email from the council on the 2nd of October, which is when the facility has expired in September, saying that we still have this whole strategy document, we still have all these things, and we can still do something to turn this whole company around. So I would just simply like to request you to take my objection on record for proceeding today without an order passed on the issue relating to the conflict of interest. We definitely need to put this to rest. And if you look at the, my humble submission today, which you read today morning, and you correlate with whatever is being said, it will be absolutely clear that had this not been this kind of conflict of interest, or had it not been bad advice, had it not been the claimant and the claimant's lawyer not being clear in their communication, which obviously we are not privy to. In fact, even at the pre-trial hearing, when I raised this point about the advice they gave on regarding 6 to 8 still continuing to be shareholders, it's on record. When the claimant's counsel and the representing person clearly said that at the time when this advice was given, they were acting on behalf of the claimant. So if the claimant was aware that there are 4 signatories which are capable of running the account and managing the instructions, why on earth would they not make us aware or discuss the matter with us and allow us to run the facility or the company as a going concern? So this is the fundamental submission which I have. I don't like to repeat some of the things which have already been said. I'm sure there will be some more technical grounds which you will hear from 6 to 8, and so I will just wait for that to be said by them. And obviously, during the course of the trial and the submissions and any other cross examinations, if there are any points which are more relevant to that particular specific person or the claimant, I will be able to bring it across to your attention at that point of time. Thank you, Your Honor.
Thank you very much. Ms. McGlone, you next. And do you want a short break before you start?
My Lord, I'm happy to proceed, but if your Lordship would like a 5-minute break, I'm happy to be in your hands.
Are you going to be half an hour, more than half an hour, less than half an hour?
I anticipate being less than half an hour, my Lord.
Right. Let's have 5 minutes and then resume at 14:50.
14:50.
17:50. Yeah. Thank you.
Sorry for the delay.
Not at all. Right. Ms. McGlone.
My Lord, this case is about the failures of the bank and of the 4th and 5th defendants to take accountability for their actions. At the end of 2017, the 6th to 8th defendants, that is Mr. and Mrs. Makajani, together with Mr. Gupta, signed personal guarantees in good faith in circumstances where they understood that they would be released from those guarantees within a matter of weeks due to the sale of their shares in the first defendant, and in circumstances where they understood that in any event, the facility for which they were providing those guarantees would come to an end in June 2018. The actions of the bank and of the fourth and fifth defendants have put those individuals in a position where now, over 4 years later, they're being pursued for sums which the bank has not particularised in any degree of detail, but which it asserts to be over $2.4 million. Now, our full case is set out in our skeleton argument. I'm not going to repeat that, nor am I going to take your lordship through a chronology of the events. But I will say a few words about the bank's claim and about my client's additional claim against the fourth and fifth defendants. Now, as your lordship is aware, there was a series of facilities between the bank and the first defendant. These were agreed for specified periods of time, and upon their expiry, new agreements were entered into. It was in keeping with this approach that the 2017 facility agreement, which is the subject matter of this dispute, was entered into. Your lordship has already been taken to this agreement, and so I don't propose to do so again. But for your lordship's note, it begins at H334, and clause 2.4, which we say is the relevant clause for these purposes, is at H347. And that clause provided that if the bank did not confirm to the first defendant that the facility was to be renewed in the next annual review period, that is from 12th of June 2018 to the 12th of June 2019, the 2017 facility agreement would expire on the 12th of June 2018, and any further borrowings would need to be the subject matter of a new facility agreement. The bank did not provide any such confirmation or undertake any such annual review, and during the course of these proceedings, it has not provided any evidence to suggest otherwise. Instead, it ignored its own processes, which were clearly articulated in its own facility agreement, and after the end of the annual review period on the 12th of June 2018, it went on to provide further lending to the first defendant, despite the fact that there had been numerous defaults, that the account was in distress, and that it had been classed essentially as a non-performing asset. Your lordship has already been taken to the memorandum which sets out those details, but again, for your note, it was dated the 15th of November 2018 and is found at I2975 of the bundle.
So the date was what?
15th of November 2018.
Thank you.
And our friend Mr. Shaheen took your lordship to it a short while ago. Now, just as there was a new facility agreement in 2017, there were also new personal guarantees. And we say that there are two issues with those. The first is that, as is set out at paragraphs 78 to 82 of our skeleton argument, which is at page A980 of the bundle, they fall foul of Article 1061 of the UAE Civil Code because they purported to guarantee future undetermined debts.
Yeah.
The second issue with the guarantees is that they were provided in order to guarantee the first defendant's obligations under the 2017 facility agreement. And when that agreement came to an end, as we say it did in June 2018, so did those guarantees, pursuant to Article 1099 of the Civil Code.
Yeah.
And our alternative case is that in any event, the 2017 guarantees didn't extend to any further borrowing after June 2018. But the result, of course, is the same, and is that the 6th to 8th defendants should not be held liable for any sums loaned by the bank to the first defendant after the 12th of June 2018. Now, there is one further point in this regard, and it concerns a resolution which can be found at page I2450 of the bundle.
Do you want me to turn it up?
I can paraphrase if your lordship would like me to do so.
Yep.
It's a resolution from the shareholders of the company, and it's dated the 19th of November 2017. And it records the shareholders' approval of the sale by the third defendant, which held the 6th to 8th defendant's shares in the first defendant, the sale of those shares to the adjuvat fund. So that's I2450. Now, although that was a resolution of the shareholders of the first defendant, it was actually produced by the claimant in their disclosure. And so, in a request for information, those instructing me asked the claimant to confirm how it came to be in possession of that shareholders' resolution. And the claimant, in its response, which Your Lordship has already seen, and which is at page F148 of the bundle, referred to a different shareholders' resolution dated the 19th of November, which indicated shareholder approval to the borrowing provided under the facility agreement. Now, the question which those instructing me had asked the claimant concerned a different resolution. And when Your Lordship looks at the response to the RFI at F148, it's clear
F1.
wording F148, my lord.
Yeah.
So one can see at the top of that page.
I'll just turn it up. Hang on. Yeah.
The top of that page in bold, one can see that the request is, please confirm how the claimant came to be in possession of the shareholders' resolution dated 19th of November 2017, referring to the sale of the first defendant as disclosed by the claimant on the 31st of October 2021. So that reflects my words a short while ago. And the answer is at paragraph number 5, and one can see that it does refer to a shareholders' resolution of the 19th of November, but the words which it quotes reflect that that shareholders' resolution concerned a different topic. It concerned consent to the facilities. So in fact, it doesn't answer the request.
Yeah. Did you go back on it?
We only received this response last week, and so we have not gone back on it. But it's the 6th to 8th defendant's understanding that the resolution which indicated that there would be a change of ownership, i.e. the resolution which approved the share sale, was provided to the bank as part of a suite of documents, which included the resolution to which this response refers. And the fact that the bank ignored this aspect of the RFI in its response, and its response, of course, is verified by a statement of truth, indicates that the 6th to 8th defendant's understanding on this point is correct, that the bank did receive the second resolution, the full suite of documents, in November 2017, when the lending was being agreed, and that it was, or that it ought to have been, aware of the share sale and resulting change of ownership in the first defendant at that point in time.
Mm-hmm.
Turning next to the question of the bank's losses, there are two issues for the court to consider here. The first is that the bank has failed to provide any sufficient details of its loss. Its own witnesses simply assert, in parts of their witness statements, which are virtually identical to each other, that the bulk of the loan remains outstanding. The second issue for the court to consider is that the bank has failed to mitigate any such loss. But in its response to the request for information, which I showed Your Lordship a moment ago, it appears to recognise that it ought to have done so, because it stated at page F151 that in good faith the claimant tried to mitigate the matter. And of course, a learned friend, Mrs. Khan, also indicated in her oral opening submissions earlier today that the claimant had tried to mitigate the matter. Now, as your lordship heard from my learned friend, Mr. Shaheen, the recall notices were issued in September 2019, and at that date, the bank held pledges over the first defendant's plant and machinery. Now, as at June 2018, and according to the June 2018 financial statements, the value of those assets stood at an amount which was equivalent to 3.8 to 3.9 million US dollars. For your lordship's note, although I won't take your lordship to it, that's at page I2877 of the bundle.
And when, sorry, what date was that?
June 2018.
Yeah.
Could I ask your lordship, please, to go to page I3375 of the bundle?
Yeah. 375.
3375.
3375. Yep.
At the bottom of that page, your lordship can see that there's an email from Mr. Kuchimanchi, the fifth defendant,
Yep.
to the CEO Dubai at UBI and to Mr. Chezian, who's one of the bank's witnesses.
Yep.
And it begins, "Dear Mr. Manoram."
Yep.
On top of the next page, Mr. Kuchimanchi says, "I received a message from the CEO of Dubai Industrial City that DIC is proceeding with auctioning the assets of the first defendant to recover the pending rental amount." Now, at paragraphs 3 to 8 of that page, your lordship can see the actions which the first defendant, or the fifth defendant, I apologise, had taken in the weeks prior to that email on the 1st of October. So he explains at paragraph 3 that he'd arranged many calls and interactions between yourself and DIC to secure a workable solution so that the bank doesn't lose BIL's assets. At paragraph 4, he says that if the assets are sold out in auction, DIC may recover their money, but the bank will lose the valuable security. Paragraph 5, I've confirmed a couple of times to the bank that there's an investor willing to acquire the factory, but they need to see the factory. And in order for DIC to open the factory, the case has to be withdrawn. And so outstanding amounts due to DIC need to be settled. Paragraph 6, during our last meeting, DIC had agreed to withdraw the case if they are paid at least the last year's pending payment of 550,000 dirhams. And at the bottom of that paragraph, I was very disappointed to note that the bank is not willing to pay DIC. Paragraph 7, I have also assured the bank that the rental income will be recovered from the potential investor and the bank will not lose any amount. And then just on to the following page and paragraph 8, the bank has an exposure of $2.6 million, and by paying less than $200,000, the bank can protect its security over the assets without letting DIC auction the same for scrap value.
Yeah.
And I should say as well that 550,000 dirhams, which is the amount that DIC was seeking, is, as I understand it, equivalent to approximately 150,000 to 200,000 US dollars.
What was the figure in dirhams? 550.
550.
Yeah. It's about 4 to 1, isn't it?
approximately. I mean, obviously there are variations in fluctuations in the exchange rate, but it's about that.
Rule of thumb, 4 to 1 is about right.
Yes. But as your lordship is aware, of course, the bank chose not to spend those sums, which it would recover, in order to secure the assets for itself. And so instead, DIC auctioned off the plant and machinery in 2020, and it's certainly the 6th to 8th defendants' understanding that it achieved approximately 25% of the actual value of those assets. And it's our case that the bank ought to have intervened and sold the assets itself in order to mitigate its losses, and that if it had done so, it could have recovered the majority, if not all, of the sums which it now seeks by way of these proceedings, without having had to incur the costs of these proceedings, and indeed without having had to engage in them. And of course, as your lordship is aware, and indeed as Mrs. Khan indicated earlier on, the engagement with these proceedings has not been entirely straightforward. So moving on to the bank's evidence, if I may. The bank has called 3 witnesses, and various paragraphs of their evidence appear to be very similar to each other, and their evidence fails to explain why the bank provided further facilities which had not been requested in circumstances where there were multiple payment defaults, the account was in stress, and the business appears to have been in disarray. They also fail to state the precise amount which the bank contends that it's owed. We heard some of the specifics of that for the first time in Mrs. Khan's oral openings earlier today. And there's also no witness evidence for trial from Mr. Rajat Grover, who's the bank's risk officer. Now, his name was mentioned earlier today because the bank produced a witness statement from him which dealt with the question of the service of these proceedings, although it didn't have permission to do so. And the signature page of that witness statement stated that he was in Dubai. And so it seems odd that the bank has chosen not to call a risk officer to give evidence on its compliance with its own policies and procedures in circumstances where it appears, as far as we can see, that one is available. And the 6th to 8th defendants asked your lordship to find that the reason why the bank has not produced Mr. Grover as a substantive witness in these proceedings is because he would not be able to say honestly that the bank had complied with its own risk policies and procedures. Turning now to the additional claim.
This again is D4.
This is against D4 and D5.
Yeah.
Now, in respect of this claim, it's helpful to be aware of the way in which D1 was managed. D4 and D5 were its managing directors. They were on the ground, dealing with D1's financial affairs and operations.
Yeah.
The 6th and 7th defendants' involvement was less direct. They were listed as signatories, but as your lordship is aware, to all intents and purposes, it was the 4th and 5th defendants who provided signatures when they were required.
Yeah.
And the 8th defendant, Mrs. Nakajani, was not involved at all. She's the wife of the 6th defendant.
Yeah.
And when the 4th defendant approached the 6th to 8th defendants about a sale, they were keen to accept the offer. And that's explained at paragraph 40 of our skeleton argument, which I won't pull up at this stage.
40.
Yes, your lordship. Now, I'd like, if I may, to take your lordship to page I2391 of the bundle.
2391.
Yes, ma'am.
Yep.
Your lordship can see that this is a document dated the 14th of November 2017. And the heading on the document is Adjuvat, and which was the purchaser of the 6th to 8th defendant's shares. And about halfway down the page is a heading. It says binding term sheet.
Yeah.
So this is the term sheet for the acquisition of the 6th to 8th defendant's shares by the 3rd defendant in D1, and it reflects the factual context in which the 6th to 8th defendants agreed to provide the personal guarantees. Now, on the next page, I2392,
yeah,
one looks at the 3rd box from the top, which is financial due diligence. First paragraph there is audited financials have been shared and management has advised that the company has obtained enhanced term loans and working capital facilities from their bankers, i.e. the November 2017 facilities. So it's all happening at around the same time. And then the next box down, binding terms, says this term sheet is binding. And then at the bottom of the page, execution of documentation, the continuing directors of Velocity, so that's D4 and D5, will be fully authorised by the other shareholders to sign and execute all documents for the transfer of shares, including POAs for any transfer of shares of Umaku Trade Invest Limited, that's the 3rd defendant, and then over the page, in order to create minimal change of shareholders at the LLC level. And then once we're on that page, I2393, at the bottom of that page, in the box named Bank Loans and Obligations, your lordship looks at the top 2 bullet points. The company will ensure that the takeover of bank loans by the investor, and this will be completed in a timely manner. And then the 2nd bullet point, exiting shareholders will be allowed to withdraw their personal guarantees and obligations. And that document, or that term sheet, was followed a few days later by the document which is at I2445.
Yeah.
So we can see that that's a 19th of November 2017 agreement for the sale of shares.
Yeah.
And then if one goes over onto the next page of that, at I2446, and clause of section 2, important conditions covering the arrangement.
Yeah.
I'm working from closer to the bottom up, if I may. Paragraph C says this business sale would be based on mutual trust and confidence. And that reflects the 6th to 8th defendants' approach towards D4 and D5 in their business dealings generally. They reposed trust and confidence in them. And that's why they agreed to sign the guarantees in 2017, although they were reluctant to do so because there was no real financial incentive for them to do so, not least because they wouldn't be involved in the first defendant any longer. So that gives a sense of the context. And then just above that, at subparagraph A, we have an indication of the consideration to be paid. And then it states all the liabilities, including the bank loans standing in the name of D1, shall be taken over by the adjuvat fund. Personal guarantees given by the existing directors/investors from Umaku and Velocity shall be replaced by appropriate documents to be provided by the adjuvat fund. This process will be completed within 60 days of the drawdown of enhanced facilities. And so it was the 6th to 8th defendants' understanding that D4 and or D5 would procure the release of their personal guarantees by no later than late January 2018. They understood and they were reassured by D4 that he had indeed done this and that the claimant was aware of this change. It's subsequently become apparent, of course, that the release of the guarantees was not procured and that D4 also failed to make the claimant immediately aware of the change in D1's ownership. And I make that point without prejudice to the point that I made earlier regarding the suite of documents provided to the claimant in November 2017. Now, D4's position on the additional claim is that he provides a bare denial in both his statements of case and indeed in his evidence. He seeks to shift blame for what has happened, as your lordship heard a short while ago, but crucially, he doesn't dispute the actual content of the additional claim. And similarly, D5 issues a bare denial in his statement of case, insofar as the additional claim is directed against him. And he provides no mention, or he makes no mention, of the facts which give rise to the additional claim in his evidence. He only deals with it insofar as it's made against him, and even then, he doesn't provide his own version of events. Again, he seeks to shift blame for what has happened, but he doesn't dispute the contents of the additional claim. Now, the nature of the 4th and 5th defendants' responses to the additional claim mean, in our submission, that it should succeed without more, and that those parties should be ordered to indemnify and or pay a contribution to the 6th to 8th defendants if, contrary to our primary position, they're found to have any liability to the bank. Now, there's one final point I'll make, my lord, which is that part of the shifting of blame in which the 4th and 5th defendants engage involve allegations of fraud made by each against the other. But what they do seem to agree on, and what their respective experts seem to agree on, is that some sort of fraud did take place in respect of D1. Now, I'm not going to ask your lordship to go to this, but the schedule to our skeleton argument, which is at A998 to 999, sets out the payments which the bank made to companies which appear on D4 and D5's accounts to be associated with either one of those individuals. And the second page of that schedule at A999 shows that the total payments made by the bank to such companies comes to nearly $2 million. As I say, I make that final point. But unless I can assist your lordship any further, those are my opening submissions.
No, well, thank you very much. I think that probably takes us beyond the end of the day in terms of the timetable. Is that right? What time is it in Dubai?
My lord, I believe it's about 6:20 in Dubai.
So that would be the end of the day anyway. Right, so I think we don't have time to start the witness.
It's 6:21 now.
Yes.
You're not in
It's
Dubai, Sarah?
we don't have time to start the witness, is that right?
No,
No, I agree. I was saying that. We'll start tomorrow morning at 11 o'clock Dubai time. Shall we, in fact, would it be sensible to make, unless it's inconvenient to parties, shall we just make that as a start every day? To start at 11 o'clock Dubai time, 8 o'clock UK time for the future, for Tuesday, Wednesday, Thursday, Friday. Does that inconvenience anyone?
No.
Are you all happy? And we'll aim to. Sorry?
Your Lordship, but Thursday, no. Thursday and Wednesday, I cannot because there are other appointments.
You have other appointments before
Stay at
before
those.
9 o'clock. Very
Yes, 11 o'clock UAE time.
For tomorrow.
Yeah.
But you can't do. Sorry, I can't. I'm only half hearing you, Mr. What are you saying about tomorrow? About the day after tomorrow?
Tomorrow is okay. We can start at 11, but Wednesday and Thursday have a problem.
I see. Okay. Well, maybe we'll again start again on Friday at 11, if that suits. But we'll discuss that as we go along. Very well. And we're having Mr. Chezian first tomorrow, starting at 11 o'clock, followed by Mr. Kumar and then Mr. Maniram. Is that right? We may not finish, I suppose, Mr. Maniram. It depends on how time goes. Very well. We'll resume then at 11 o'clock Dubai time tomorrow. Thank you very much.
Thank you, my lord.
Good afternoon.
Good afternoon.
thank you.
Thank you very much.